Morning, everybody, and welcome to the Arizona State Board of Pharmacy meeting. My name is Lori Walmsley, and I will call the meeting to order. The date is December 10th. The time is 8:30. Dr. Gandhi, if you want to do roll call and conflicts of interest, please.
Thank you, Madam Chair. Mr. Braswell. Mr. Thorwald.
Present.
Ms. Browning.
Present.
Ms. Davis. Ms. Walmsley.
Present, conflicts have been submitted.
Ms. Park.
Present, conflicts have been submitted.
Mr. Hogan.
Here.
Mr. Nassif.
Here with no conflict.
And Mr. Anderson.
Here, I do have two disclosures, no conflicts for tab 4L, case 25-0472, and tab 4M, case 25-0487.
Thank you. We have 7 present, 2 absent, Madam Chair. And just as a reminder, Madam Chair, as we get to those agenda items that there's recusals or disclosures, just identify that you are disclosed or recused and a reason behind it.
Thank you, Dr. Gandhi. A couple housekeeping notes. CE is available for those in attendance in person today. If you're interested in CE, please make sure that you sign in the back. CE will also be available for the afternoon if you attend after lunch, so make sure that you sign in both times. We will move to item 3 on the agenda, approval of the meeting minutes.
Madam Chair, I'll make a motion to approve the minutes.
I second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. That takes us to tab 4, which is the complaints, the consent agenda for complaints. I have a couple of items that I'm going to go ahead and pull that were noted for full board discussion or at the request of staff. Items 4E, 4J, and 4U. Is there anything else that other members would like to pull for further discussion?
Madam Chair, I'd like 4A, 4C, 4H, 4K, 4P, 4Q, and 4Y, please.
We should have done the ones that we weren't going to pull, Jeff.
P as in Paul.
PQY. Anything else? All right, let's go in alphabetical order for discussion then. Item 4A. This is complaint 250367. A prescription was filled with the incorrect medication. Dr. Anderson, would you like to start since you're asked to pull it?
Sure. Thank you, Ms. Walmsley. So I do appreciate the complaint committee's review on this case and commendation for the actions taken post-event, but I can't support the recommendation of only 3 hours of non-disciplinary CE for the involved technician, and this is why. The technician bypassed the required barcode scan, which is required by their company policy, and which is critical defense against wrong drug errors like this. The safeguard exists for moments exactly like this, and the technician made a choice not to use the scanner per the standard procedure and policy. Specific drugs involved make this even more concerning. The fact that flecainide was mixed in with the folic acid and dispensed to the patient could have been tragic, and if the patient did not notice, and I'm grateful she did, but this near harm event underscores the gravity of bypassing barcode scanning. So I'd like to ask Ms. Fuentes, she I believe was the compliance officer on this, if there was any evidence to show that the scanner was not operational or any information was provided by the respondents as to why the bottle was not scanned.
Thank you, B. Go ahead. Turn on your mic.
Sorry about that. Good morning, everyone. Beatrice Fuentes, Compliance Officer. No, they did not provide that information to me at the time, and there was no further information as to why he bypassed it.
Thank you, Ms. Fuentes. So as a board, we committed to applying that NVP decision tree to guide our assessments of accountability, and bypassing that required safeguard is categorized to me as reckless or at least at-risk behavior in that framework. And it reflects a disregard for established risks, and even recommending only non-disciplinary CE just does not match the seriousness of this conduct. And I think it sends an inconsistent message So I do agree with the pharmacist's misdetection during visual verification aligns with non-disciplinary CE, but I think the technician's actions are different. And they warrant a disciplinary response proportionate to the reckless conduct that I see here.
Thank you, Jeff. Discussion.
I agree with you, Mr. Anderson, about the seriousness of this medication, specifically this medication. Now, but the question is, I believe there's two mixed medications in one bottle. Does the system allow to scan both? Because I know some system you can only scan one bottle. So, but I agree with you like about like the seriousness of those like mix, especially with the flecainide.
So I would offer a motion that we would accept the complaint committee's recommendation for the pharmacist and the permit, but for the technician, offer a consent agreement for 3 hours of disciplinary CE in the area of patient safety and error prevention to be signed within 30 days and CE completed within 90, if not, move to hearing. But the consent agreement would make it disciplinary for the technician. That would be my motion.
Do I have a second or any other discussion?
I'll second.
Dr. Gandhi, do a roll call since it's discipline.
Certainly, Madam Chair. Mr. Braswell? Mr. Thorwald?
Aye.
Browning?
Aye.
Ms. Davis? Ms. Walmsley?
Aye.
Ms. Spark?
Aye.
Mr. Hogan?
Aye.
Mr. Nassif?
Aye.
Mr. Anderson?
Aye.
Ayes have it, Madam Chair, with 2 absence.
Thank you, Dr. Gandhi. We'll go to 4C next, complaint 25-0418. This is the complainant stated that his prescription was written for 3 milliliter vials 4 times a day for 90 days, or 4 vials per day and 360 vials, but the pharmacy shorted his prescription and only shipped 270 vials, even when the provider increased his prescription to every 4 hours, which was 540 vials for a 90-day supply. Dr. Anderson, you requested to pull this one.
Yes, Ms. Walmsley. The complaint committee recommended referring the pharmacist to their home state, and the committee expressed that there should be accountability for what occurred, and I do agree, and that's, there were also, that committee was unsure on how accountability could be achieved given the jurisdictional limits, that the pharmacist was not licensed in Arizona. During the meeting, Dr. Gandhi also mentioned that Ohio may not take action because the complainant is an Arizona resident. And I'd like to better understand more about that if more information is available now. Dr. Gandhi or staff, any information on that comment that was made?
I did reach out to the Ohio Board of Pharmacy Executive Director, and it seems like they do have jurisdiction over this pharmacist. I wanted to confirm that as I knew it was gonna probably come up during this meeting.
Thank you. And also just, I think this raises a broader concern. Many Arizonans are similarly situated to this patient and receive medications from out-of-state mail service pharmacies. And those pharmacies aren't always staffed by Arizona licensed pharmacists, yet they provide care to our residents. And that makes it important for us to understand what options we actually have when safety issues like this arise and our authority applies only to their permit. And just to recap, that this event was the pharmacist reduced the quantity of the combination albuterol and protropium nebulizer doses without notification to the patient or the prescriber. They failed to consider the maximum use. They didn't counsel the patient on why they were sending less than what was ordered. The patient experienced real distress. So I'd like some guidance on, how we can appropriately frame any violation or responsibility at the permit level, since they're the only one licensed, given that the pharmacist is licensed elsewhere. Is there any sort of recommendation or guidance that the board staff or board council can provide to us to foster accountability with the permits when it's their staff that are unlicensed by this board that make errors?
Mr. Anderson, I do believe that that is something that we could look at, perhaps maybe in terms of a rule revision to clearly delineate the responsibilities in a situation like that.
Thank you, Ms. Galvin. I have no other comments, Ms. Walmsley.
So the recommendation of the complaint committee was to dismiss against the permit since it was an individual pharmacist decision and that resulted in the issue for the patient and to refer to the home state. Is there a motion? Do we want to uphold the motion of the complaint committee? Thoughts?
Yes, I'd like to uphold the motion of the Complaint Review Committee, and I'm pleased to hear that Ohio will consider the case.
I'll second.
So the motion will be to dismiss the permit and to refer to the Ohio board. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Item 4E is complaint 25-0092. A pharmacy inappropriately compounded and tested ketamine patches on an employee. This was pulled, I believe, for full board discussion. Is that correct, Dr. Gandhi?
That is correct, Madam Chair. This is one that I spoke to you about to kind of pull in so we can discuss further. I think one of the recommendations from staff was to add the California pharmacy and pharmacist to this complaint. And my hope is to have them keep them separated, just for the fact that California is doing their own investigation about that location. There may be other information that arises through our discussion with them. And so if we can keep those two separated, that'd be appreciated.
And the recommendation from the complaint committee was to bring this forward for a conference at the next meeting.
Correct.
Any discussion or a motion?
So the motion would be to open a complaint, no,
To keep the
Separate,
two
yeah.
matters separate
to matter separate.
and move the current complaint to conference.
So I move to move the current complaint to conference and separate the,
Keep
the
the
California
Arizona location and Arizona.
and adding the
locations.
pharmacist to, separate complaint.
Second.
Any discussion? All those in favor?
Aye.
Any opposed? Motion carries. That'll take us to item 4H, complaint 25-0469. A refill prescription was dispensed with the correct label placed on an incorrect unit of use container. Dr. Anderson, you asked for this one as well.
Thank you, Ms. Walmsley. This, I believe, is board staff, Mr. Wagner. Mr. Wagner, I do have additional questions, very similar to the first case that I pulled. Their policy of the board, their policy indicates that it's supposed to be scanned, and neither the pharmacist or the technician in their responses indicate whether or not that was bypassed, the scanner was not working. Can you provide any clarity around that safety guardrail that?
Good morning, board members. Dennis Wagner, Compliance Officer. The only information that I was provided, I believe, is in your packet on page 708 that shows the scanning details.
Do you know what that accuracy scan means? It says accuracy scan origin. What does that mean?
Unfortunately, no, I don't know what that stands for.
708.
708.
To me, it looks like they did do it.
Right, because I saw that too. It said origin accuracy scan, but if they actually scanned it, how did this happen?
They didn't really provide a response to that.
It looks like Mr. Hyber may have some insight into this organization.
Good morning, board members. Steve Hyber, Compliance Officer.
I have a similar case coming up, 25-0515, I believe that's the number. And I was just looking at that this morning as your line of questioning started going down that road. And I have the similar documentation, same pharmacy operation. I would venture a guess that it's just to identify the filler. Because remember, many pharmacies will identify the various steps involved and they'll use the scanning process. Because one would logically think if they were scanning the stock bottle and then the prescription bottle, then they would get a mismatch. And it wouldn't allow them to proceed. So, but I've never verified that, in an actual case. So, might need to dig a little further on that conference or something like that with their IT people.
What do folks think? Do we want to learn more what this actually means, accuracy scan? It says, according to this document, it appears that it was scanned, but clearly they got the wrong drug.
Are we able to table it and come back to it at the next meeting for further discussion? I don't know that I think we need to have a conference. I think we just need to ask CVS the question.
Agree.
I agree with that as well.
Is that an option, Ms. Galvin? Can we table it till February?
All right, I'll make a motion to table this complaint until the next board meeting. And
Second.
compliance officer to get more information on.
Mr. Hyber, since the facts of that other case were roughly the same, that was item 4Q.
Because that's why I pulled that one too.
Oh, yeah, you already have that one pulled.
Yes, it is 4Q, and it was, as I stated earlier, 25-0515. And it's very similar. We have a wrong drug, and there is a scan step, which you can observe on page 1478.
Right, that's why I pulled that one as well, Ms. Walmsley. So, I mean, we can table 4H and
And
4Q.
4Q.
Thank you.
Do I have a second? All those in favor?
Aye.
Any opposed? Hearing none, motion carries.
Madam Chair.
Yeah,
Let me
go ahead.
go back to 4E real quick. I did overlook one other discussion point. We'd like board's permission to subpoena appropriate individuals to compel them to appear at the conference.
That
could be added
totally
to the
makes
motion.
sense to me. There's a lot of individuals named here. I'm supportive of that. Do you need a motion?
No, he's been directed. Unless there's an objection.
Yeah, I definitely have questions for the people that are listed on this complaint and would like to have an eyeball-to-eyeball conversation next time.
Thank you.
Okay, that takes us to 4J, I believe, 25-0470. I am recused from this discussion, so I will step aside.
So this is complaint 25-0470. Board staff is Mr. Castaneda, respondent is Walgreen 4266. Pharmacist Scott Grassel and technician Aristeo Tubalon. The complainant received prescription for the incorrect person in the mail. So we'll open the floor for discussion. There's no discussion. Happy to entertain a motion.
So this particular item was pulled from the consent agenda. And has anyone indicated why they pulled it from the consent agenda? So I can understand what we're talking about.
It was not pulled from the consent agenda, but rather the complaint review committee forwarded to the full board for in-depth discussion.
I think there might have been a question with the pharmacist verifying what's been put in the bag, maybe the processes around that.
Right. So as I recall reading this complaint, the tech had set the prescriptions next to the mailing container, and somehow the pharmacist added the prescriptions to the wrong container, and it was mailed to the wrong person. Is that others' recollections?
Now I'm just trying to look at my notes. So basically, because there's no evidence what happened, if you look at the last line of the complaint, it says, but did not show enough detail to determine when the error occurred. You know what I mean? So, and that's the reason we brought it back here, just to hear different perspective. So,
Board members, if I may, please.
yeah.
Yes, please.
Ben Castaneda, Compliance Officer, Arizona State Board of Pharmacy. When I submitted the packet for the complaint review, I noticed that the technician's response was not included in the packet. So we brought it in front of the full board so that the response could be added. It is now on page 983 in your board packet. The technician did indicate that he set the prescriptions up for each individual to be mailed, and video footage did not show enough detail to determine where the error was made.
Thoughts?
So I'd like to ask anyone on the complaint committee if what would their recommendation have been? I mean, can you recall the conversation, and how would the recommendation align with other recommendations that you make on these complaints?
I cannot recall, but I believe that requested by the staff, right, to table this one. So there is no discussion took place during the just because we are waiting for this piece of evidence, which is Mr. Castaneda mentioned this on 983.
So I see two options. We could refer it and have the pharmacist and tech come in and try to get to the bottom of it, or we could assign some type of continuing education on error, non-disciplinary.
I mean, it is to me. I don't know if we need. I mean, it is dispensing error, right? It is dispensing error.
Yeah, I'm leaning toward non-disciplinary CE for medication error. I don't know if anyone else has any comments on that regard.
For both the pharmacist and the technician?
I think so, since it's undetermined.
I would agree with that.
And dismiss the permit? Okay, so we have a motion for non-disciplinary CE for both the pharmacist and the technician respondent. Dismiss the permit. It's 3 hours of CE in the area of patient safety or medication error prevention. We've got a first and a second. Any further discussion?
Mr. Chair, if I may add, Ben, did you have anything to add, or is that?
No, that's all. Thank you.
Thank you.
Thank you. All in favor, please say aye.
Aye.
Any opposed? Motion carries.
Okay, that takes us to 4K complaint 24-0099. A pharmacist billed for test kits and sent them to patients without their authorization. Dr. Anderson, go ahead.
Thank you, Ms. Walmsley. The Complaint Review Committee asked for a conference, and I am supportive of that, but wanted to discuss the possibility of issuing a subpoena to Walmart for records. I'm really curious on what financial incentives and bonuses were paid to this pharmacist as a result of these kit sales, and any eligibility for quotas and performance targets based on those sales of kits. I really want to understand that, to understand the driver of his behavior. And is that possible to issue that subpoena?
Yes, you may.
All right. Yes.
I second.
So you would want to table this matter and have the staff issue a subpoena to Walmart.
Not necessarily table, because I think the Complaint Review Committee through it recommended it go to conference. So I'd like the subpoena issued between now and conference so that information's available for us at conference.
That I understand, but just to ensure that it is clear with staff that we get the material before we hold the conference.
Yes.
Yes.
Is that your motion?
Yes.
Do I have a second?
Could I have discussion?
Yeah, please.
So on page 986, last paragraph, apparently the pharmacist responded, the pharmacist in question, if I'm on the right case, and stated they only ordered, filled, and sold the test kits. Oh, okay. Never mind.
Okay, I have a motion on the floor to take this to conference with the subpoena. All those in favor? Aye. Any opposed? Hearing none, motion carries. Let's go to 4P, 25-0428. A former employee alleges that the pharmacy requires monitoring for safety and compliance.
Thank you, Ms. Walmsley. So I'd like to offer an alternative perspective to the Complaint Review Committee's recommendation. The committee suggested a letter of concern for this permit, but the facts support a stronger corrective response from my perspective. The most concerning issue is that this pharmacy is not following their own policy, which requires medications to be supplied and stocked in the most ready-to-administer dosage form. So despite that policy, they're compounding norepinephrine drips that are the same concentration and diluent as multiple commercially available premixes. These premixes are stable, standardized, and widely used in emergency settings. I checked several manufacturers and the FDA drug shortage website. Norepinephrine premixes are not and have not been on shortage. The PIC never cited availability concerns as a reason for compounding this, which makes this really a choice of stocking rather than a necessity. The FDA has been clear that routinely compounding drugs that are essentially a copy of available commercial products is discouraged. Their policies also leave critical gaps that Mr. Hyber noted. While the pharmacist may be better suited to compound immediate use preparations than the nurse, their policy doesn't explicitly require a pharmacist preparation in emergency situations. And because the pharmacy chooses not to stock premixes, nurses are forced to compound high-risk meds after pharmacy hours. And clearly that's not consistent with safe practice, nor does it align with their internal standards. So I really would recommend a consent agreement for, I'm not sure whether a letter of reprimand or a decree of censure on this. They need to really evaluate and identify all of these immediate use compounds that they're making and look to see what commercially available premixes are available. This is a non-24-hour small freestanding ED without 24/7 pharmacy services. They don't even have a clean room. So it's all immediate use preparations, and their policy says to use premixes, and they're not using them. They're stocked and commercially available, and that's the safest way for Arizonans to receive meds in these sorts of very acute settings. So I would recommend something a little bit firmer than just a letter of concern for modifying their policy, because the one policy that they do have that is pretty good, it says that they're going to administer and ready to use for, or they're going to stock ready to administer drugs, and they don't. And that's a problem. So those are my thoughts on this case.
So specifically to the permit holder, right? We're not talking about the pharmacist there?
Correct. I think the PIC should know. I think, the PIC should know that these are commercially available products. I mean, this is standard director of pharmacy stuff in a hospital. I mean, you're looking at what's commercially available and trying to minimize compounding, particularly in a quick setting like this, and looking at your code cards, looking at your contents of your code cards, and making sure that if it's available in a ready-to-use format, why are we going to try to add mix on the fly? Even in the PIC's response, he comments that the ED physician was irritated on how long it took to prepare the Norepi drip. And it's available as a premix. So there's no need to go back to the pharmacy or compound it, in this immediate use setting.
I have a
Mr.
question for
Hyber.
Mr. Hyber. You're an inspector, right?
Yeah.
I saw you looking at me, so I figured you were going to call me.
You know me too well.
Yeah, indeed.
So, did Mr. Hyber, did you look at the shortage stuff? I mean, that wasn't included to my recollection in the reading here. I'm like, thank you, Jeff, for looking at that, but I also feel like we need to hear from our inspector on that.
I appreciate that. No, I bow to Mr. Anderson's superior knowledge. This is one of the reasons why we have a very diverse board, because there's going to be blind spots as far as particular issues. And Mr. Anderson, obviously being intimately involved in that area of pharmacy practice, knows those things and looks at them every day. So it's a very good point, very good issue to point out. It's wasn't brought up in the actual complaint. Again, we focus our investigation on the actual complaint, and we did note that the policies were somewhat weak in many regards. They didn't spell out anything about the pharmacist being involved in a code situation, and he is correct. This is a very small, low bed count, almost like a little corner ER type operation. In a rural community, and they would be best served, obviously, if they could reduce the amount of compounding. But the compounding that was performed, much to the allegations, none of these allegations were substantiated.
Which is why I have an issue with going all the way to a consent agreement for discipline. I feel like perhaps we should bring them in and ask some more questions, perhaps have Mr. Hyber provide that sort of shortage information. I don't want to go all the way to the point of discipline. When I'm glad that you brought that up, and I think it's a very valid point. However, that information is not in our packet, and I don't want to issue discipline with somebody without having all the appropriate questions answered.
Yeah, Mr. Anderson, you have a great point, you know what I mean? And thank you for mentioning this. But we don't know what's happened at that time. Maybe they always use premix, but at this time, they didn't have it for some reason. So the pharmacist should act it.
Maybe they don't have access to the same
Access, you know
suppliers.
what
I
mean?
mean,
So we don't know. So it's good to hear from them, I believe, so exactly what's happened. Thank you
And-
for mentioning.
And I might add, this pharmacy, contracts out to a consultant pharmacist. So, some of that it's not like there's a resident pharmacy director there, even though on paper, the PIC would be the director. I think, and they've had some high turnover as well. So I think that played a role in the situation. And again, this individual filed a complaint. It was day one of training. The person only trained for one day, and they were thrown immediately into a code situation. And in spite of them maybe having prior hospital background, I think it was ill-advised. Again, the training process, really wasn't done properly. And again, there's no violation there, but it's probably what generated this complaint in the first place.
So I would move that we move this complaint to conference.
Second.
and then Mr. Hyber, if you could also try and obtain some of that other information around the shortage and advance of that conference, I think that would be good.
Sure, I can do that for
Thank
you
you.
folks.
Any other discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. We'll go to for you 25-0068. Goodness, that's going slow. The complainant provided a written request for the full board to review the executive director's decision as he disagrees that there was no violation of the Pharmacy Practice Act. The complainant alleged that the pharmacist substituted their judgment for that of Dr. Harkins and that he was not qualified to prescribe medications. The suggestion from the recommendation from the complaint committee was to uphold the director's dismissal. Dr. Gandhi, I believe this item was pulled because we have a request from, I believe, the complainant to speak.
My name is Ed Gaines. I'm a lawyer for Dr. Harkins. And this has to do with education to the pharmacists. The American Dental Association has had for 5 years a specialty in oral facial pain management. And so this is not a dentist who does crowns and fillings and whatnot. He looks after the patients who have difficult problems, either from temporomandibular joint dysfunction all the way through trigeminal neuralgia. And all we're asking for is that perhaps there are only about 20 certified specialists by the ADA in this area of oral facial pain. Maybe to do an article in your magazine, your monthly magazine, to educate pharmacists, because I understand pharmacists like dentists, what the heck are they doing? But a lot of these problems are chronic, long-term, and require medications that are not typically in the bailiwick of the average general dentist. You know, I've submitted Dr. Harkins' qualifications. He's an old dog like I am. I've practiced law for 44 years. I've spent most of my time looking after doctors, hospitals, and pharmacies. I've represented Walgreens and CVS, and professionals and board complaints. We're just asking that the pharmacists be educated as to this particular specialty so they're not shocked when they get something that seems outside the box.
Thank you for your time. Board members, discussion?
This is Dr. Harkins, if I may speak.
Yes, please go ahead, doctor.
I've been practicing this specialty for 44 years in Tucson. I've never practiced general dentistry. I've seen over 40,000 patients in my career, primarily chronic temporomandibular joint disorders, associated head and neck pain, neuropathic pain in the head and neck. The majority of our patients are referred to us by neurologists and pain clinics and ENT physicians and other dentists. And I've not had a problem with this. For 44 years, usually the pharmacist calls me if there's a question on prescribing a muscle relaxer or a narcotic or a sleep medication. It hasn't been an issue. But recently, in the last 3 years, I've had multiple issues with pharmacists telling patients that I'm not qualified to be writing prescriptions, in this case for a muscle relaxer, which the patient has been taking for several years, and telling the patient that I'm a DDS. DDSs don't prescribe these kind of drugs. And then upon me talking with a pharmacist, having her laugh at me and tell me that it's the most ridiculous thing she's ever heard, that a dentist would prescribe a muscle relaxer, and hung up on me. And this kind of stuff is irritating. I had a similar situation with another complaint that's coming up next with a Walgreens pharmacist. All I'm asking, and I had provided my credentials to this patient and some documentation of my training and background, but it doesn't seem to matter. And I just, what happened to Arizona Statute 32-1965.01? I'm curious, where is this exemption that pharmacists can use their own judgment to refuse any prescription and interfere with our continuity of care? So that's my concern. Not that I want to punish anyone, but I want pharmacists to know about this, because they don't have time. We don't have time to go through this over and over and over again. And I've had 2 more instances in the last week with pharmacists refusing to fill my prescriptions because I'm a dentist. And so anyway, that's my concern, is to educate the pharmacist so we can avoid this in the future. By the way, the prescription that this pharmacist in this complaint refused to fill was filled by another pharmacy, no problems. So that's my concern. And I'll shut up.
Thank you, Dr. Harkins.
I think it's about education. We're just wondering if we can educate the pharmacists out there about this particular specialty and the fact that dentists who have this specialty or who've been practicing it for 40 plus years know what they're doing. And I mean, I understand the pharmacist point of mind, but in any event, thank you for listening to us. But we would love to get an article into your monthly magazine that just educates about oral facial pain specialists.
Thank you. Appreciate that. Board members, discussion? The current recommendation is to uphold the director's dismissal.
So obviously the point raised is there a way to educate pharmacists relative to this specific
I think
practice?
that's kind of out of scope of the complaint.
And that was my-
in my personal opinion. I mean, Ms. Galvin, is that correct? If we want to talk about that at a different time, we can. We're here to adjudicate the complaint.
That is correct. If there's a larger issue that you think needs to be addressed, we can do that at a future meeting.
So my question is there some precedent or example of a similar nature where the board directed staff to, within the regular newsletter, include an article that would be educational in nature?
I mean, this is my personal perspective. I understand where they're coming from, and Dr. Harkins is clearly very qualified. However, the narrative that we received back from the pharmacist is they were trying to contact the prescriber to get additional information to clear red flags, because it isn't very common for a prescriber to prescribe this medication. So they were trying to ask questions. They're saying categorically they didn't deny filling the prescription. It wasn't filled because they didn't get the answers that they needed to fill the prescription. So I still feel that there has not been a violation here. And I think that we should uphold the dismissal. Perhaps there is some opportunity to do some education. I don't know. Perhaps that's something that the Pharmacy Association could look at, but ultimately pharmacists have a corresponding responsibility, and that's why there's checks and balances. It's a requirement of the DEA. It's a requirement of our law. And I think we should stick with the complaint committee's recommendation. That's my personal feeling.
Yeah, I agree with that. And then, just to note on this case too, this patient was new to this pharmacy. And so, prompting additional review and reaching out to rectify those red flags. And so I support upholding the committee's recommendation.
It seems like the communication could have been better by the pharmacy team, for sure, but.
Can I respond to?
No, we're in discussion, Dr. Harkins.
The response from the pharmacist is not true. I spoke with her at length and she hung up on me laughing. You obviously didn't read my complaint, the whole thing.
We certainly did. If we're in discussion now, please. Any further discussion, or do I have a motion?
Motion to uphold the complaint review committee's recommendation.
Second.
Any further discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. I think that brings us to our final item that we've pulled, item 4Y, complaint number 25-0438. I am recused from this one as well. Take over.
Thanks, Ms. Walmsley. I did ask for this one. This is respondent Walgreen 4077, Madeline Yu, pharmacist, and Diana Altamirano, technician. Before I present my comments, would compliance officer Mr. Hyper please come forward just to clarify a few points unclear for me, and this is a different organization than the prior organization. So first, according to the technician's response on file, She asserts she followed the standard operating procedures for filling the methylphenidate prescription. However, Walgreens audit log shows that the scanning step for the bottle was bypassed. It says bypassed. I'd like the compliance officer to explain what that means in practice and how this discrepancy could occur. Is this referring to scanning of the barcode on the bottle, or are we still have some unclarity with this pharmacy chain as well?
Good morning again. I think I was bad. I moved the mic. I think we're having that problem again with the mics. Obviously, one of the prescriptions were scanned. It's possible there was a return to stock. It's possible something else occurred that nobody knows or remembers. It's also possible the individual put the medication in there. We can only go off of the information that we gathered and the responses that we received. Anything beyond that would require just speculation. I did do an audit, and we did find that the audit indicates a possible mixed medication because the medication that the patient should have received and did not receive fully, that medication is over in the audit. And the medication that they did receive, that they shouldn't have received, is short.
Steve, let me just clarify one comment you made. The document on the Walgreens audit log that I see, it said the scanning step of the bottle was bypassed. And you just made a comment that at least one may have been bypassed, or can you clarify that, Steve?
Oh, I'm sorry. I misspoke then.
Okay.
Yeah.
So, I'll just summarize for those who weren't here for the complaint review committee. The patient was expecting 240 methylphenidate tablets. Mixed in that bottle were oxycodone 5 milligram tabs, a medication that she was never prescribed. She experienced adverse effects and fell. Inventory variances that support the possibility of the misfill, and the tablets are visually similar. And the Walgreens audit report confirms that barcode scan was bypassed. So again, this is very similar to 4A. I'm comfortable with the complaint committee's recommendation for the pharmacist that the pharmacist missed the mixed tablets on the visual verification, which aligns with human error. But again, the technician consciously bypassed that critical barcode scanning step, particularly, with Schedule II narcotics. It just elevates this conduct to at minimum at risk, and suggests a somewhat haphazard approach to her workflow. And for these reasons, I believe that the technician should receive very similar to what we did for 4A, consent agreement for 3 hours of disciplinary CE in the area of patient safety and error prevention to be completed within 90 days, and uphold the complaint review committee's recommendations for the permit and the pharmacist. And that would be my motion.
I would just like to mention one thing for outpatient services or retail. Not all barcode are scannable. And sometimes not every vendor allowed to scan every single bottle. You might use 3 or 4 bottles to fill one prescription. They only allowed to scan it once. And I don't think we can keep holding. I agree with your concern. You know what I mean? Like if there is a policy, but sometimes policy not doable sometimes because of the fact of technology. So that's why I look at those sort of the error as a human error, and majority of human errors because not following policy for a reason or another reason, not always malicious or reckless. It could be just part of technology or workflow. Things happened, right? And then if you ask the respondent what's happened at that time, they cannot recall, because if they remember what happened, they would not make a mistake. So really, they try to gather as much as memory they can and to respond to our state board. So That's the thing about scanning and bypass. We don't know what's happened at that time. And I don't think the respondent would know. Actually, they both denied that they did the mistake. The only evidence, right? The only evidence we had is based on the staff audit that they found like shortage in one medication and overage in the other med.
They also responded, and one of them responded in there that I said something about everything being okay on the audit. I think what they're referring to, because when I leave after doing my audit, I don't have all the data yet. We're unable to run reports in the store for this particular company. So I think what they're referring to is I ask them what their on-hand counts are to make sure we haven't missed anything in our closing count. And if the count matches that, I go, okay, we're good on that, because I know I haven't missed anything. You know, like there might be a spot where they've put a drug out of order on the shelf and they didn't pull all of their stock in order to get an accurate count. And one other issue might be at play here. I'm thinking this particular company, when you utilize, because I see scanner overrides on when they use return to stock bottles to fill a prescription. So it's possible. I mean, people aren't going to know that because there's no record of that. But one of the fingerprints of utilizing a return to stock bottle, in other words, the drug's in the bottle, it's been returned to stock, but they're using it because they can, because it was never picked up. There's going to be a scanner override signature on that particular transaction.
Correct.
And that's possible they had two bottles pulled that were returned to stock, thinking they were both the right drug, and they were not.
And also, if the barcode is faded for a reason, also you cannot scan it. It doesn't mean the medication is not good. Is you can read everything there, right? So you have to override it. The way they override it, they type the NDC.
Understood.
hand, yeah.
If those are habitual issues, those things need to be escalated and resolved. I mean, this is an inherent safety safeguard that these companies are investing. They're putting resources in having dollars allocated for barcode scanning for their employees to use, not meant for employees to bypass this technology, because we know this saves lives. And that's what we're here for, is safety. And the organization provides barcode scanning. I don't know what the word bypass means. You know, if it was, you know, a return to stock bottle, but it says it was bypassed, and that's concerning to me. And the respondent, the technician, didn't indicate why it was bypassed. They didn't even address it because they didn't follow their company's procedures, in my opinion, and that's why they didn't address it in their response.
Yeah, one good addition would be when you bypass, you have to put a note in somewhere so there is a record, because again, these complaints come in downstream, and people don't have a memory of why they even bypassed it, let alone they can't even remember that they filled it as well. So it's difficult without all that data.
Yeah, if my team members were having issues with scanning something, it would be escalated and we would work to resolve the scanning concern. And I would think that if there was a habitual problem with a particular manufacturer, they would work to either not purchase that manufacturer or do something to ensure that the safety procedures that they've made these investments for work.
Of course, like, to talking about safety, I totally agree. Like, I mean, we don't want to see errors, but really we don't have a lot to say to hold vendors like accountable on something. And then the technology is to assist pharmacists and technicians to do a better job, minimize errors. At the end of the day, it is a licensee responsibility to make sure they're providing safe and accurate medications to their patients. Now, I know our licensees like becoming like more like using the technology for safety, but we don't want to get to the point, you know, man, it is a permit holder or it is a vendor issue. And then why do we need pharmacists there or like a technician? I believe, I agree with you. I mean, it says bypass, but from this case, specifically this case, they did not admit, they didn't say they bypassed or they violated their policy. They only, what they said, they don't recall. But what the system register, I don't think we'll be able to get this information. I mean, we don't know what's happened at that time. Because, I mean, I cannot speak on this on behalf of any permit holder. I can speak on behalf of the system I'm aware of. If you type a NDC using your hand, it will show bypass. You know what I mean? It doesn't mean like we ignore the policy. I mean, this is like my perspective. Now, if I can confirm there is a violation of policy and the bypass because they violate their policy, I would agree with you 100%.
Yeah, I agree. I don't know that we know exactly what happened here. So that's, you know, that's kind of where I'm at with it.
Can we do the same that we did with the CVS? With the CVS complaints and get some more information on what bypass means in this case and what their company policy states regarding the scanning so that we have a better picture?
And is there a note on the bypass? Like, do we know why they did bypass on this one?
No, like I said earlier, it doesn't capture any information, any detail. Because there again, there could be several reasons. I think Mr. Al-Nasif actually brought up another one. If you manually input the NDC, essentially you haven't scanned it, so it's going to register that as a bypass.
Yeah, and I don't know, based on the responses that we have today, if we brought them in, that we would hear anything different.
So I think we need more clarity. Is there a duty? Did they breach their duty? The company has a policy that it must be scanned, and if it's not scanned, then they breached that duty. I mean, what does the company policy say from Walgreens about barcode scanning technology?
So we can certainly pull that. Part of the problem I think some of us have had is trying to find someone within that large organization who knows all the pieces, all the moving parts. But we'll dig deeper.
Do we want to table together more information?
Seems consistent with what we did with the two CVS cases. So my motion would be to table this and have the compliance officer get more information on the scanning and the company policy on scanning and workflows. Any further discussion? All in favor, please say aye.
Aye.
Aye. Any opposed? Motion carries. Welcome back, Ms. Walmsley. We're done with.
Actually, I'd like to go back to item 4A. Based on the discussions that we've had about two other organizations, I feel like we should potentially change our action. So if it's possible, since we're not all the way through this, Jean, am I able to ask to open that discussion again?
Yes, you may go back and reconsider.
So I would like to do the same with item 4A that we've done with the others. I feel like if this is a direction that we want to go, I feel like we should, I think this is an opportunity for us to learn. So I would like to rescind that that action and move forward.
Yeah, I mean, just to be consistent, I would agree, but I like just to comment thing. Maybe some people won't like it, but to me, like, you know, it is a human error, right? Technology is there to assist, to help. It is not to do the job, right? And that's why we have pharmacy technician, we have pharmacists in each pharmacy. Plus policy, I agree. I'm a big policy follower. We don't know at emergency situation or something happens, do we need pharmacists? I mean, I cannot say that, but we need the pharmacists to act like pharmacists. You know what I mean? We need technicians to act like technicians. There is many cases that I'm gonna speak on for my practice. You know what I mean? Like, it's hard to write policy. You cannot capture everything in your policy. It is kind of impossible. I would agree with you to bring also for 4A just to be consistent and see what the concern in the community. But really internally, I would say I still hold individual accountable for any errors, because that's why we require have pharmacists and PIC and a technician in the pharmacy.
I 100% agree with you, Tariq, and I can understand why they don't necessarily remember what happened. I don't remember the date on this complaint, but it has been a long time. And you're right. I mean, you brought up a lot of reasons why you couldn't scan something. I mean, sometimes the barcode is damaged on the package when you received it. Sometimes the outer box is damaged. It's a return to stock and it's torn or something like that. I mean, things happen. There's a lot of reasons why it could be overridden, and I imagine that they probably have something in their policy that how to address those situations, but there's no reason why they can't use the inventory. We don't require barcode scanning. So
Correct, but we also agreed to look at this NAPP decision tree. And, you know, I'm trying to embrace that tool. And that tool talks about conscious disregard, disregard for policies, et cetera. And it kind of directs, and it's been, you know, vetted through a number of state boards of pharmacy. I think Mr. Nassif and Ms. Walmsley, you may have been there when it was debuted in Fort Lauderdale, and endorsed by the National Association, and we agreed to adopt the framework. And when you have people breaching certain duties, I think it escalates above just a human-related quality event. And I think human-related quality events should have non-disciplinary CE. If there is something greater than that, at-risk conduct, reckless conduct, not following procedures that you're able to follow, then we need to be considering that in the discipline that we issue. So I'm agreeable as well, just for consistency, that we bring Safeway as Safeway back too, so that we have Safeway, CVS, and Walgreens, so we understand the barcode technology, what bypass, what override means, what the expectations are for technicians and pharmacists when that happens, and you know, just let the public know that this is an expectation. Their employer has put this investment in this technology for them to use, and by bypassing it or overriding it without some legitimate reason has a concern for me as a board member and concern for public safety, because this has been shown to save lives, and we cannot continue to allow these things to be bypassed and overridden when there's no reason to do it.
Ms. Fuentes?
Yes, hi, Beatrice Fuentes, Compliance Officer. I just want to bring it to your attention for my case 4A. On page 33, I did provide a snippet of their SOP about what the NDC.
Yep, we got that. Thank you. So do we have a motion?
Second.
I didn't make a motion. I said, do we have a motion?
Oh, I thought I heard one. I apologize.
Do we need a motion to rescind our previous vote?
Yes.
I move we rescind our previous vote on A4A.
I second that one.
All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Now, what do we want to do?
So I'll make a motion to table 4A. It seems like from what Ms. Fuentes has pointed out on page 33 that we know their policy, that they're supposed to scan. So we need to review the documentation. I'm not sure if that's currently in the book.
I reviewed it, but I assume that there are circumstances that, like Tariq mentioned earlier, that there may be a supplemental policy. Perhaps that's not their only policy. So let's request that additional information. What happens when there is barcode scanning that's overridden? Like, what are the scenarios? Is that built into a policy, et cetera?
And that would be my motion.
And I second.
I have a motion and a second. All those in favor? Aye. Any opposed? Hearing none, motion carries. How's everybody doing? Do we want to take, let's take all the rest of the complaint agenda. Actually, we could probably do the rest of the entire consent agenda together. The rest of tab 4, all of tab 5, tab 6, and tab 7. We could do together. Yeah, somebody that doesn't have any recusals, can they make the motion?
I move that we accept the other
Yeah.
tabs that have not previously
Voting on this item.
been mentioned.
Tabs 4 through 7?
Yes,
The remainder of 4 and all of 5, 6, and 7.
correct.
Second.
I have a motion and a second. Dr. Gandhi, let's do roll call since there is A, disclosures, and B, discipline.
Certainly, Madam Chair, thank you. Mr. Braswell, Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis, Ms. Walmsley,
I noting recusals.
Ms. Park,
I noting recusals.
Mr. Hogan,
Aye.
Mr. Nassif?
Aye.
Mr. Anderson?
No recusals, but I've got two disclosures for 25-0472. I just want to disclose that an executive from the permit holder approached me about potentially serving on their pharmacy director advisory board. An agreement was never finalized and I never served in that role and evaluated the case impartially. And then on case 25-0487, I want to note that I've been a customer of that respondent pharmacy, but that does not influence my perspective and evaluated the matter fairly and without bias.
I do have a recusal on tab 5, D 25-0580, just personal friend of mine.
Okay. Want to take a quick break? How's everybody doing? Huh?
Do we vote?
Did you take the vote?
I did.
Yeah.
Okay, thank you.
I was like, I thought he did.
Ayes have it, 2 absence.
Yes. Let's come back at 9:45. All right, welcome back, everybody. I think we've got everybody. Yep, we're all accounted for here.
Madam Chair, before we get started,
go ahead.
had a request that we speak up a little louder. They're having a hard time hearing it at the back of the room. So if we can move closer to the mic, that'd be appreciated.
Okay. We are gonna go to item 8A, which is complaint number 25-0034. This is respondent Jennifer Stupy. We actually have a request from counsel for the complainant, I believe, to table this till later meeting. Hi, good morning. If you could unmute yourself and please introduce yourself for the record.
Kristen Basha here on behalf of Dr. Stupy.
Jennifer Stupy.
Nancy.
Good morning, Nancy Chang, Compliance Officer from the Arizona Board of Pharmacy.
Ms. Basha, I think we have a request from you. Is my understanding correct? You'd like to table this till a later meeting?
We would. We only received the investigators' recommendations the day before Thanksgiving break, and that identified some specific regulations that were possible violations. So we would like more time to collect the complete records and address that.
Okay. Any discussion or do I have a motion?
Second.
Do I have a second?
Second.
All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. We also have the matter of Ms. Stupy's license renewal, which is item 18A. Given the fact that we're not going to adjudicate the complaint today, I think it would be appropriate for us to extend the license until the next meeting or whenever we hear the complaint.
I'll make that motion.
I'll second.
All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you for being present. We'll see you next month or 2 months.
Thank you so much.
We'll go to items 8B, 8C, and 20C, and I am recused, so I'll let you take over, Jeff.
Thank you, Ms. Walmsley. So tab 8B and 8C, these are bundled for board members under 8C. This is board case number 25-0626 and 25-0640. Board staff is Ms. Brown, and are you Mr. Lawrence Rush? Welcome, Mr. Rush. Ms. Brown, could you please give us a brief summary?
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Lawrence Rush was issued an Arizona pharmacist license by Reciprocity on December 23, 2013. His license is currently suspended. Mr. Rush is appearing before the board today for discussion, consideration, and possible action regarding 3 separate but related matters. I will be presenting them together in the order in which the events occurred. For agenda item 20C, board case number 25-0456, on July 28, 2025, staff received notification from Walgreens that on July 10, 2025, Mr. Rush arrived for his evening shift, showing signs of impairment. He was subsequently terminated for unprofessional conduct based upon for-cause testing results. Documentation from Walgreens indicates that the results of a breathalyzer test were 0.308 at 5 p.m. on July 10, 2025, followed by a result of 0.292 16 minutes later. Staff sent Mr. Rush a notice of complaint and options for next steps in this matter. He responded, apologizing for the complaint, and explained that he and his wife went out for dinner and drinks to celebrate their anniversary on the evening of July 9, 2025, and that he should have taken the next day off. He also opted to enter into an interim consent agreement for interim suspension of license and substance use evaluation. His complete response is included in the board's files for review and consideration. The board considered and approved Mr. Rush's interim consent agreement during the October 2025 board meeting, and it was executed on October 23, 2025. Mr. Rush underwent an evaluation with a board-approved provider, and the results of the evaluation are included in the board's files for review and consideration. For agenda items 8B and 8C, board case numbers 25-0625 and 25-0640. On October 28th, 2025, an anonymous complaint was submitted to the board office alleging that Mr. Rush interviewed for a pharmacist position in September 2025, presented himself as still employed by Walgreens, untruthfully explained his legal troubles as a DUI, and did not disclose that his license was suspended. Mr. Rush responded to the complaint and indicated that he did apply for jobs as a pharmacist. However, he denied the allegations and asserted that he was completely honest in his representation. His complete response is included in the board's files for review and consideration. Of note, a provision of Mr. Rush's interim consent agreement that he signed in August 2025 states that during the period of suspension, he shall not practice pharmacy or hold himself out as a practicing pharmacist or in any way convey to the public that he holds an active license to practice pharmacy. On October 27th, 2025, another complaint was submitted to the board office by a representative of Metastar Healthcare alleging that Mr. Rush interviewed for a pharmacist position on or about September 16th, 2025, untruthfully explained the suspended status of his license as a DUI, and untruthfully stated that there was not a consent agreement with respect to this matter with the board. Mr. Rush responded to the complaint and indicated that he believes the complaint is the same as board case number 25-0626, and his response was the same as the last complaint. It is included in the board's files for review and consideration. Due to the similar allegations of both cases, it is reasonable to assume that they are likely related due to the same incident. However, as board case number 25-0626 was submitted anonymously, staff was unable to confirm this. There's also the matter of Mr. Rush's renewal that will need to be considered. Mr. Rush's license expiration date prior to suspension was October 31st, 2025. Staff has not received an application for renewal at this time. The board may wish to consider allowing staff to approve an application for renewal contingent upon a complete and accurate renewal application with no additional concerns and his compliance with the board's decision with respect to the complaints, or require another appearance to discuss the renewal at a future date once the application is received. These matters are before the board for discussion, consideration, and possible action regarding the facts of each complaint, the underlying conduct, the suspended status of Mr. Rush's license, the results of his evaluation, and next steps with respect to his renewal.
Thank you, Ms. Brown. Board members, there's a lot to unpack here. Let's thoughtfully go through and do 8B and 8C first, which are the complaints from the MedStar Health and the anonymous complaint. So we'll open the floor for questions regarding those complaints.
I've got some questions
Certainly.
in regard to that. So my question relates to when does the actual consent agreement become effective? When the respondent signs it or when the executive director signs it? Because, well, let me ask that question.
The consent agreement has a provision that it is effective upon the signature of the respondent and the executive director, and then it is ratified by the board at the following meeting.
So is it safe to say that technically, when Mr. Rush was interviewing, that technically there was not a consent agreement in place?
Jenica, you may have a better idea of the dates.
The interim consent agreement was executed on October 23rd, 2025. The complaints that were submitted to the board refer to interviews occurring in September.
So even though, it makes the discussion that happened at the interview a little murky in the sense that technically, I don't believe that there was it didn't sound like there was an actual consent agreement in place.
Thank you, Mr. Hogan. I do have a question for you, Mr. Rush. The complainant in these cases reported that you shared with them that you had a DUI in February. Can you tell us about that?
That's what I explained to them, and I explained to them about.
Excuse me, could you use your mic?
Oh, I'm sorry about that. No, when I had the interview, I explained to them the whole situation, and I wasn't attempting to
to get the job done. I explained to him about I'm going through like an interim consent agreement, and like I have to find out what the outcome of that is when I went for the interview at Metastar. I just felt like if I waited to the end of when everything is completed, and then it's going to take more time to get a job, and I didn't work since July, so I was just trying to get something rolling, but not intention to work until like everything is clear with my license. But I explained that all to them when I went for the interview, and I was upfront with them, and I told them about the the upcoming interim consent agreement. I said I have to do the evaluation, and they just told me to follow up with them and let them know, after I complete the evaluation, to just keep communication with them pretty much. And that was how it was led.
So Mr. Rush, my specific question was, they said that you told them you had a DUI in February. Did you have the DUI in February?
Yes, and that's why I was explaining that, and I was explaining the interim consent agreement as well.
So do we know about this DUI in February?
I have not been made aware of a DUI in February.
Yeah,
So how many DUIs do you have?
February 10th.
So how many total DUIs do you have?
One was put back, but that was like about 8 years ago. But that was it. That was everything.
So this is going into the next case, and this is kind of jumbled, Ms. Galvin. So we don't have any. You didn't report this DUI in February to this board. This latest DUI that you're now telling us in public forum that you had in February.
I believe I did, and then this came up as well. So it was like both of the things came up basically at the same time. So that's why I reported everything, and I reported everything to that employer as well. I just was telling them that I was going through the interim consent agreement, and waiting the outcome of.
But the interim consent agreement was for having a blood alcohol content of 0.308 at Walgreens. It was not related to the DUI. So now you're telling us that you had a DUI in February and you were terminated from your employer for being grossly impaired at work. And that was what the interim consent agreement was for. Is that correct, Ms. Brown?
That is correct. The findings of fact in the interim consent agreement are around impairment in the workplace.
I'd never had anything to drink at work or anything. I've been a pharmacist for 30 years. I practiced in, community pharmacy, hospital pharmacy, nuclear pharmacy in multiple states. I graduated from Philadelphia College of Pharmacy in 1995. I never had any issues like this. So like for this aspect from 8B and 8C, I didn't know, like I wasn't attempting to get a job and be hired like the next day. That's why I fully disclosed, and I gave him my license number, and I said,
But Mr. Rush, you didn't fully disclose. You told them you had a DUI in February, and that complainant told us that we're learning that you had a DUI in February through this complainant. And today you're confirming that you had a DUI in February, and we only knew about the impairment at work. And that's why we had the interim consent agreement for you, and why you saw Dr. Sideman, which moves into tab number 20C. So I think we're going to have to be a little fluid here, Ms. Galvin, and move into that agenda item.
Understood.
So, Mr. Rush, you told the evaluator that you stopped drinking earlier that morning. This is in regards to the anniversary. Can you?
Mr. Anderson, if we are going to discuss what was relayed during that evaluation, we should move into executive session.
Okay, let's do that. Can we make a motion, or I'd like to make a motion for executive session to discuss PHI.
Second.
And legal advice if necessary.
And legal advice if necessary.
Second.
All in favor, please say aye.
Aye.
Aye. You want to join us? We're gonna take 7 minutes. We're gonna take 7 minute break. Yes. 6 or 7.
Can you hear me now?
All right, we're back from executive session. Welcome back. Board members, we had some good discussion with Mr. Rush, and Mr. Rush also had some discussions with board staff. After further discussions, it seems like Mr. Rush may be agreeable to voluntarily surrendering his license, and board staff can coordinate that with you. If that voluntary surrender is not signed within, is it 30 days?
Probably 14 business days,
14.
2 weeks.
If that voluntary surrender is not signed within 14 business days, then we would entertain a separate motion that I think Ms. Browning may
Yes.
formulate.
So we'll make a motion to table this and ask staff to contact the evaluator, asking to reevaluate the information we got, the additional information, and open a complaint for not reporting the February DUI.
So, all right,
And that motion would also include offering a consent agreement for the voluntary surrender. And if that's not signed, then this,
Then this goes in.
correct. All right, Dr. Gandhi, roll call, please.
Who was?
Oh, I'm sorry, who was,
Stephanie.
okay, we've got a first and a second. Dr. Gandhi will do roll call, please.
Thank you, Mr. Chair. Mr. Braswell, Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis, Ms. Walmsley's recused, Ms. Spark,
Aye.
Mr. Hogan,
Aye.
Mr. Nassif.
Aye.
Mr. Anderson. 6 ayes, 1 recused, 2 absent, Mr. Chair. Ayes have it.
Thank you, Dr. Gandhi. Thank you, Mr. Rush. The board staff will be in touch with you. Thank you.
Okay. Where are we at? Item 11A is a non-resident pharmacy permit application requiring board review. Simply Pure RX. Is someone present from Simply Pure?
Hello. Yeah, I am present. My name is Fadi. I'm the PIC and the owner.
You're muted if you're speaking.
Hello, can you hear me?
Is someone present
Hello,
from
can you hear
Simply
me?
Pure?
Can you hear me? Hello? Hello, can you hear me?
Can't hear.
Staff, do we know if someone's present?
Hello?
Looks like it.
Hello, can you hear me?
Can you see the name? Same. Ram, do you want to go ahead and give us a summary? We see if we can get this other respondent unmuted.
Good morning, board members. This is Ram Kalapuri, Compliance Officer with the Board of Pharmacy. Simply Pure RX is based in Evanston, Illinois. Applied for a non-resident independent pharmacy permit from the Arizona State Board of Pharmacy on 6/4/2025. The licensing department found an undisclosed home state disciplinary action.
Ram, I'm so sorry to interrupt. I think the room might not be unmuted.
Do you want me to start over? Yeah.
Hello?
Madam Chair, we may have to reset the computer here, so if we could maybe take a quick little recess.
We're going to take a 10-minute recess due to technological difficulties.
One, two, 1, 2, 3. It's working. Hello, for those of you who are on the Zoom meeting, we're going to need to restart the Zoom because we are not hearing when you are talking to us. So you will need to rejoin. Sorry for the inconvenience.
Thank you, Len. Okay, we will go to item 11A, Simply Pure RX, non-resident pharmacy application requiring board approval. Is someone present from Simply RX online?
Yeah, hi, can you hear me?
Yes, we apologize for the technical difficulties we had earlier.
No problem at all. Yeah, my name is Fadi Musla. I'm the PIC and the owner of Simply PRX.
Thank you so much. Ram, if you want to go ahead and start with the review, and then we'll go to the PIC.
Good morning, board members. This is Ram Kalapudi with Arizona State Board of Pharmacy. I'm a compliance officer. So Simply Pure RX Inc., based in Evanston, Illinois, applied for a non-resident independent pharmacy permit from the Arizona State Board of Pharmacy on 6/4/2025. The licensing department found an undisclosed home state disciplinary action against the pharmacy during the permit application review process. When Simply Pure RX Inc. was under a different PIC former partner, the pharmacy was placed on probation in June 2019 due to inspection findings, and the consent agreement was signed with the Illinois Division of Professional Regulations in July 2020. The current pharmacist in charge was silent partner during the pharmacist's June 2019 inspection. The current pharmacist in charge took over the responsibilities on 3/11/2020. The probation termination was signed on 10/14/2025. The issue before the board is the failure to disclose the disciplinary action on the permit application.
Thank you, Ram.
No problem.
Mr. Musil, would you like to, Musla, would you like to address the board, or do you want us to jump into questions?
No, we could just jump into questions. That's fine.
Okay, so our compliance officer, Mr. Kalapuri, mentioned that you were a silent partner at the time that this discipline occurred. Is that the case?
Correct. Yes.
So why didn't you notify the board when you made your application of your prior discipline from Illinois?
I thought we did. So I have actually a consultant that's filing in multiple states for me, and he's doing all the applications. And I thought I'm pretty sure he sent that over, because I sent him the consent forms, and he knows all about it. And I'm pretty sure he sent it to all the states. But I apologize if I didn't see the communication for that.
Madam Chair, the page number 2826, you can see it. They did not disclose.
We've also communicated with the compliance officer
Yes,
via
I believe
email
that
as
was
well.
after the point of the original application. So the question on the
Oh,
application.
I see. Okay.
Has any formal disciplinary action ever been taken against any of the permits held by this business at either a state or federal level? Yes. If yes, provide the further details. And the question was answered no.
I apologize about that. I did not know that. Yeah, I did not know that. This is the first I'm hearing of that, to be honest with you. Once again, this is through a consultant that's filing all these applications on my behalf. Again, I apologize. I would not have told him not to do that. I specifically told him, gave him the consent order, and told him about the probation multiple times, and he's aware of that.
Mr. Muslah, will you please just share from your perspective or your about the probation? And I know it's terminated right back on October 14, but could you just give us a brief summary about the probation and what's happened?
Yeah, that probation was the former PIC misinterpreted the law in our compounding pharmacy, thinking that if he compounded things that are over the counter strength, that we would be able to sell them without a prescription. But that was just only like 6 items of one naproxen gel that we or he put up for sale. So it wasn't a large amount or anything like that. And he just, it was in good faith misinterpreting the law, stupidly, I might add. But, and unfortunately that's what happened. And we never did that again.
Madam Chair.
I took over right away after, and he resigned as PIC, and I bought his shares a couple of years later.
I have summary of those findings from June 2019 inspection, if you like.
But I don't think it's necessary.
And
But thank you.
There were 2 inspections that were completed after the June 19 inspection, and they were fine.
Thank you.
So the only reason we're here because failure to disclose, and it is $250 fine, right? And non-disciplinary. Okay, and this is my motion: approve the application with the 250.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you for being present.
Thank you. We appreciate it. Thank you.
Item 11B, Quick Fill Pharmacy. Is anyone present from Quick Fill?
Yes, present.
If you could please identify yourself for the record and your position with the company.
I'm Naim Vladimir Lenchitsky. I'm an owner and PIC at Quickfield Pharmacy in Tarzana, California.
Thank you. Mr. Kalapuri, can you give us a summary?
Again, good morning, board members. This is Ram Kalapuri, Compliance Officer with Arizona State Board of Pharmacy. Quickfield Pharmacy based in Tarzana, California, applied for a non-resident independent pharmacy permit from the Arizona State Board of Pharmacy on 8/14/2025. The licensing department found an undisclosed past discipline, a public reprimand for the PIC, Vladimir Lenchitsky, from 2017 on the California Board of Pharmacy website. On March 10th and 11th of 2015, the California Board of Pharmacy inspected the Unicare Pharmacy, which Mr. Vladimir Lenchitsky partly owned at the time, and found 24 prescription drug stock bottles containing more tablets or capsules than their labels indicated. 2 drug stock bottles had half tablets, 1 prescription drug in a bottle with another pharmacy's label. Those are described in page 2891 and 2892. The pharmacist in charge received a citation from his State Board of Pharmacy in 2013 for DUI. Also received a citation for failing to maintain accurate records for C2 prescriptions and C2 controlled substances received in 2012. And then Quickfield Pharmacy website features prescription blanks with pharmacy details. The PIC agreed to add a statement that these prescription blanks are not acceptable for patients in Arizona. A review of their website download center on 11/28/2025 shows Dexcom, Omnipod, Diabetic RX prescriptions. All of them include a note stating they are not valid for Arizona patients. So the issue before the board is for failing to disclose discipline on the permit application again.
Thank you, Mr. Kalapuri. Mr. Lenchitsky, would you like to address the board or for us to proceed with questions?
Please proceed with questions.
Thank you. What was your role with the pharmacy when this discipline occurred? It seems as though you were also named personally and during that time.
I was the owner of the partial owner of the pharmacy, one of the partners.
Did you complete the application?
To the Arizona board?
Yes.
Yes, our compliance officer completed it, and I supervised the process. I actually spoke to the compliance officer present in the room, and I do believe we disclosed that case from 2017, which actually resulted in an accusation withdrawn by the Board of Pharmacy, California. And we did fix the prescription blanks stating that it's not for Arizona residents.
From I believe when I reviewed the application, the question was, had they ever received discipline? And they answered no, correct?
Yes, the page number 2868 shows that.
Okay.
So all this communication is after the fact.
Okay. Once you did the initial application review?
Yes.
So Mr. Lenchitsky, why did you answer no, that there was no discipline has there ever been any formal discipline taken against any permits?
Yeah, I apologize. Just as a previous pharmacist, I was pretty sure that we did submit it. I think the application to Arizona Board of Pharmacy was done online. I don't have any paper in front of me, but if it wasn't submitted, I do apologize. It's a public knowledge, and I didn't mean to hide it or anything like that. It's posted on the California Board of Pharmacy.
Okay, thank you.
I'll move to approve the application upon payment of a non-disciplinary civil penalty of $250 for failure to disclose.
I'll second.
A motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you for being present.
Thank you very much.
Item 13A, Premium Health Services. Is anyone present for Premium Health Services?
Yes, I'm present.
If you could please introduce yourself and your role with the record.
Dylan Hurley, compliance officer.
Are you able to turn your camera on?
No, I do not have a camera in my office.
Okay. Mr. Patel, if you could give us a summary, please.
Premium Health Services applied for a non-resident wholesale permit in Arizona. During substantive review, it was discovered that Premium Health Services had failed to indicate that this application was for a change of ownership, and it also failed to notify the Board of Pharmacy that the change of ownership had occurred. The change of ownership occurred on July 1st, 2025. The application for a new permit was filed a little over a month later on August 11th, 2025, but also failed to indicate that this application was for a change of ownership. On September 23rd, 2025, board staff verified and confirmed with the applicant that this change of ownership occurred on July 1st. Rule requires that the permit holder apply for a new permit within 14 days before there is a change of ownership. This application is in front of the board for consideration due to failure to indicate the change of ownership in the permit application and untimely notification for the change of ownership. Thank you.
Thank you, Shrug. Mr. Hurley, would you like to address the board or would you like us to proceed with questions for you?
Yeah, so the license, we didn't have one in the state. I think 2017 is when it lapsed, and that was due to a lack of customers. And then our new owner wanted us to apply for a license again in Arizona. And that was what I was doing for that. I just wasn't aware that I had to show that it was new ownership until I received that message.
But you intentionally let your license lapse, and then when you reapplied, that's when you notified us of the change of ownership when the questions occurred with the staff?
That's correct. I didn't know I had to show that change of
Previously.
ownership. Yes.
Okay, thank you. Board members, additional questions or discussion?
So what's the fine? Is it the same 250 or 500? It's 250? Yeah, okay. So I move to approve the application with $250 fine for failure to, or late notification, change in ownership.
Second.
And issue the license, right? Or permit. Issue the permit, yeah. Upon payment, paying $250. That covered all, right?
And I'll amend my second to include that information.
Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Item 18B, Animal Health International, Inc., doing business as Precision Logistics. Is there anyone present for Precision Logistics?
There should be some folks on the screen.
Hello, Mr. Morris, if you'd like to introduce yourself and then your client.
Sure. Roger Morris, counsel. Kelly should be on.
Yes, I am on.
Kelly, if you can state your name and position for the record.
Kelly Carew, I'm the regulatory licensing manager.
Welcome. Ms. Fuentes, if you could give us a summary, please.
Excuse me, B. Fuentes, Compliance Officer. Animal Health International, DBA Precision Logistics, HAI, submitted application for a non-resident wholesaler permit and disclosed several disciplinary actions spanning from 2013 to 2025. During the substantive review, AHI was questioning regarding its failure to report a 2021 cease and desist order issued from Arizona. In its initial written response, AHI did not acknowledge the 2021 C&D from Arizona, but instead referenced a different C&D issued from the state of Nevada Board of Pharmacy 28HI and Amalga, Utah, dated in July 9th of 2025, for not possessing a Nevada wholesaler license for the sales of non-prescription veterinarian drugs. They were fined $5,000. In subsequent correspondence, AHI confirmed the existence of the 2021 Arizona cease and desist to AHI in Ocala, Florida, for shipping drugs, non-prescriptions, or prescription drugs into Arizona without a valid permit. AHI did not disclose because they did not consider the action to be disciplinary in nature, and it did not lead to disciplinary action. Additionally, drugs distributed into Arizona were not from the Ocala location, but rather from AHI's distributor in Memphis, Tennessee, which has a license in Arizona. In addition to the above, AHI disclosures included a 2020 case in which AHI entered a plea of guilty for introducing into interstate commerce misbranded veterinary prescription drugs to persons who are not licensed to possess or distribute veterinary prescription drugs on the order of a veterinarian who was not properly licensed in Virginia. AHI did pay a substantial fine. No disciplines were found for the location of permit applicant.
Thank you, Ms. Fuentes. Mr. Morris, would you or Ms. Carew like to address the board?
Sure. AHI is a wholesaler that distributes veterinary prescription products. They have disclosed every discipline that they have been involved with for the last decade plus. They have numerous licenses with the Arizona board. This particular facility is a brand new facility, so you're going through the application process again, but you've had numerous disclosures of all of these issues multiple times in front of this board, including the facility that this will replace that goes on. I'm happy to give you the background. There was a number of issues involving when wholesalers distribute, and they distribute prescription drugs to feed animals, many times hundreds of pounds of drugs at the same time. And it's an issue of, can you distribute it directly to the farm and the farmers and the groups? Different states have treated it in different ways. Their major issue that resulted in most of this discipline was a misunderstanding with a number of states as to whether they could distribute directly to the farmers. All of those have been disclosed to Arizona multiple times since the 2020 settlement that went on to be able to deal with it. The cease and desist that came out in April 14th of 2021 was sent as a result of an inspection of an Arizona pharmacy here where they found some invoices. I have the cease and desist in front of me. It was ultimately withdrawn by Elizabeth Dodge when they showed that she just didn't have page 2 of the documents that was there. But the cease and desist itself says, the purpose of this letter is to advise you and provide you with an opportunity to comply with the licensing statutes. This letter is not an injunction or an adjudication concerning these alleged activities. It's not discipline. And so there's no reason to disclose it. Ms. Kelly can answer any other questions you have, but that's the background.
Thank you, Mr. Morris. Ms. Carew, is there anything you'd like to add?
Not at this time unless you have any questions.
Thank you. Board members, discussion?
Ms. Fuentes, did they disclose the cease and desist in Nevada on the application?
Not the original application, but they did it through correspondence with them.
Okay. Did they say why that one was not disclosed on the original application when on the follow-up correspondence?
I think they had to do something with their filings. It basically was an oversight on their part, but they were very clear that it was not intentional.
And I can add some context to that. It was more of like timing related to when we submitted the application related to the change of location, and then and kind of when the cease and desist had come up. So it wasn't intentional to not include it. It just was a matter of timing.
So it's just like non-disclosing, right? Failed to disclose discipline action. So
I think they disclosed.
I think they disclosed.
They didn't on the original application, which is what we just did with the last permit. Is the last permit they didn't disclose on the application. They did on the.
It wasn't discipline. The cease and desist wasn't a discipline.
Cease and desist.
The Arizona was a cease and desist that wasn't discipline, but the Nevada one is the one that I was.
That has been disclosed.
Ms. Fuentes just said that Nevada was not disclosed on the original application.
Ms. Kelly, was it disclosed or not?
It was not disclosed on the original application because of the timing of when we submitted the application and when the cease and desist had come out. It was it was kind of passing over the time. And so, but then when it was asked in subsequent communication with the board, I immediately disclosed it and said that it was an oversight, and we had disclosed all of our other previous history and discipline, and it was not intentional to not disclose the cease and desist for Nevada.
the issue in my mind is whether it's discipline or not. They will disclose it prospectively going forward. It's just that easier, it's caution to disclose everything. But I don't believe a cease and desist itself is discipline.
And that's why we didn't disclose it, because it was a cease and desist and it wasn't considered discipline.
It also included a fine of $5,000 with that cease and desist, it looks like, right? Is that correct?
That's correct.
That is correct.
But is that considered disciplinary?
Um,
We have non-disciplinary fines. Just because they got a fine doesn't mean it's discipline.
That is true. I don't know how it was categorized. I don't know if this was before the non-disciplinary civil penalty authority that was granted to the board.
So I believe that what you got a letter from the state board telling you it's not disciplinary, right?
That was the Arizona board.
That's Arizona board.
Correct.
Can we look at it?
So I think we need clarity on whether or not the Nevada cease and desist was discipline in Nevada's eyes or non-discipline.
Yeah, but if I didn't see this email or letter, but if they informed it's non-disciplinary, so does it matter?
Oh, I think my mic is dying. It does. If they answered the question no, and it's disciplinary and it had already happened, then that's a problem. Just like it's been
I
a
believe
problem with
that's
the
a
other.
problem, but if they have letter from Arizona state, no need to report.
Do we know what appears on the National Practitioner Data Bank for this pharmacy or for this wholesaler?
I'm gonna have to look into that.
Can we just table this for later today and perhaps we can find out that?
Can I make a suggestion? If it's a $250 non-disciplinary fine, I think they would prefer to go forward.
Okay.
Okay. Is that fair?
Does it matter that so in Nevada it was a is a specific license type that is not required for in any other state? As to why we were issued the discipline? Does that, and I'm trying to bring up the discipline documentation as well.
Kelly, I'm sorry. This is Alex Cooper, also with Quarles and Brady, and I've worked on this matter. I believe what Kelly's getting at is this is not an activity that the cease and desist was issued for. This is not an activity that would require licensure in Arizona. It also did not involve the facility that we are currently trying to get licensed.
Board members, if I may, I did a quick search on Nevada's license verification page, and it does not appear that there's discipline from their board.
I would make a motion that we issue the permit then.
Second.
Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you for being present.
Thank you.
Tab 14 is vacant. Tab 15A, 15, item 15A, I2 Therapeutics. A2?
That's me.
That's you. Do we know if they're present?
Present.
Good morning. If you could please introduce yourself for the record. Individuals for I2 Therapeutics, if you could please introduce yourself and your role for the record online.
Hi, I'm Dawn Cotter. I'm the senior compliance manager.
Can you hear me? Can you hear me?
There you go. Yes.
Okay, thank you.
What's your name and your position for the record?
Hello, Margaret Cabano. I am Senior Vice President of Operations for A2 Therapeutics.
Thank
and
you.
A2 Biopharma.
Thank you. Ms. Fuentes, if you could give us a summary, please.
Yes, B. Fuentes, Compliance Officer. I2 Therapeutics submitted an application for a non-resident manufacturer permit. The applicant reports no prior disciplinary actions. The applicant responded no to regulatory question 2 of the application, which asks whether any formal disciplinary actions have ever been taken against the permits held by the business. The applicant disclosed at the time of the application that its parent company, I2 Biopharma, was involved in a disciplinary matter with the Oregon Board of Pharmacy in 2023 related to an error in 2019 renewal application. I2 Biopharma accepted the responsibility, paid the fine, and the matter was closed in March 2024. Review of the submitted materials revealed that one of the applicant's contracted manufacturing organizations, VitaPros, is not licensed in Arizona. The applicant has been notified and they will work with VitaPros to obtain the required permit. Also, during substantive review in September, the applicant disclosed that it had been shipping into Arizona in the last 5 years. At that time, they disclosed a total of 507 items that were shipped into Arizona without a permit. However, staff received additional information yesterday from I2, which did not make it into the board material, with clarification on the number of items shipped into Arizona, with a new total of 325. This unpermitted activity is the reason for the application being brought before the board for review.
Thank you, Ms. Fuentes. Does someone from I2 want to address the board, or would you like us to proceed with questions?
Yeah, I think, thanks for the opportunity. So it's my understanding that we were going back for 5 years. And so what Dawn and I did was we looked back all the way to 2020. And in 2020, we had a renewal, and we weren't part of the company at the time, but the associate who handled our compliance at the time, she submitted the application under the parent company, which was Bioscience, and it was subsequently approved with all of our drug products being listed in that permit. And then in 2021, there was a name change, and she moved it from wholesaler to virtual manufacturer. And at that time, she also said in there that it was that all of our drugs were covered, both for Bioscience, Biopharma, and A2 Therapeutics. And so in 2021, A2 actually acquired our company, which was Neos Therapeutics. But the licensing and compliance stayed separate until this year. And so 2020, 2021, and 2023, all 3 of those applications into Arizona were submitted under the parent company and subsequently approved for all of the products that we're talking about for drug products. In 2025, Dawn and I took over the licensing because we had finally merged the companies. And at Neos, we always had separate licensing for all of the labeler codes. And so we subsequently started with all states, trying to make sure that we had the licensing for all of our labeler codes. And now we're down to all states have both. Except for we're trying to work through this issue with Arizona to make sure that we can, be in compliance. We take it very seriously. And so I think today we're just hoping that we can, get the approval. We did get the renewal for 2025 under our parent company, and it was approved with Arizona. And so that's just the background. If you have specific questions, hopefully we can answer those.
Thank you. Board members, discussion?
So there was an amended number of items from 507 to what was the number, Ms. Fuentes?
325.
And how was that calculated? How was that reduction calculated?
So when I was doing the review with Dawn, we noticed that there was an authorized generic product on the list that doesn't even have the labeler code in question right now, so it wouldn't have been on there. It's already approved via a different permit, and so we took it off. There were also samples which go to our sales reps that were on there that shouldn't have been. And then also we just did a designation for transparency, which of our products are drug products and which are dietary supplements.
Thank you. Board members, discussion.
So there's two paths forward. Non-disciplinary would be 30, if we agree to this 325 units, then it would be $32,500 as a non-disciplinary civil penalty and then approve. Or the other pathway through a disciplinary approach would allow the negotiation. Correct. That would be my motion.
And this is my second.
And what with the permit?
And approve the permit if the non-disciplinary is paid or if the consent agreement for the lower amount is assigned and paid.
I have a motion and a second. Any discussion? Dr. Gandhi, go ahead and do a roll call.
Mr. Braswell. Mr. Thorwald.
Aye.
Ms. Browning.
Aye.
Ms. Davis. Ms. Walmsley.
Aye.
Ms. Spark.
Aye.
Mr. Hogan.
Aye.
Mr. Nassif.
Aye.
Mr. Anderson.
Aye.
7 ayes, 2 absent, Madam Chair.
Thank you, Dr. Gandhi. Thank you for being present. That takes us to tab 18, item 18B is for Cicely Patterson, pharmacy technician. Is Ms. Patterson present? If you could unmute yourself and introduce.
Yes, I'm here online.
Ooh.
Hello,
Yes.
can you hear?
Yes, if you could introduce yourself, please.
Hi, my name is Cicely Patterson.
Welcome.
Yes, hi, my name is Cicely Patterson.
Good morning. We can hear you. Thank you.
Thank you.
Ms. Mitchell, if you could give us a summary of her application, please.
Cicely Patterson was licensed as a pharmacy technician on January 14th, 2020. She applied for the renewal of her license on October 28th, 2025. She failed to disclose an arrest for DUI on her application. On December 21st, 2023, the board office received a notice from the Department of Public Safety indicating that the status of Ms. Patterson's fingerprint clearance card had been changed to driving restricted, as she had been arrested and/or fingerprinted for misdemeanor DUI on or about December 13th, 2023. Staff searched the public access website for charges filed against Ms. Patterson but found none. When Ms. Patterson submitted her renewal application in October, she did not disclose her arrest on her application. At the request of staff, she provided a copy of the police report relating to her arrest. She also apologized for the oversight and confusion. Staff would like to note that Ms. Patterson was not required to report her arrest to this agency until she applied for renewal, as she was never charged.
Okay, Ms. Mitchell. Ms. Patterson, would you like to address the board or would you like us to jump into questions for you?
Questions, please.
Okay, thank you. Board members, discussions or questions?
I'll make a motion to approve the application upon payment of the $250 non-disciplinary civil penalty for failure to disclose.
Second.
A motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you for being present, Ms. Patterson.
Thank you.
Item 18C, Paula Beatty, pharmacy technician application. Is Ms. Beatty present?
Hi, yes, good morning. Thank you.
Good morning. If you could please introduce yourself for the record.
Good morning. My name is Paula Beatty. I'm a pharmacy technician.
Good morning. Welcome. Ms. Mitchell, if you could give us a summary.
Paula Beatty was licensed as a pharmacy technician on January 19th, 2022. She applied for the renewal of her license on September 16th, 2025. She is currently employed by United Healthcare Optum. Over the past 18 months, Ms. Beatty has reported charges including harassment, DUI, and failure to comply with a court order to the board staff. She did not disclose all of the previously reported charges on her renewal application.
Thank you, Ms. Mitchell. Ms. Beatty, would you like to address the board?
Good morning. Thank you for taking the time to review my application. This was a complete error on my mistake. I was rushing through the application while I was at work and I disclosed all of the charges. I just forgot to disclose the DUI charge. I did email you guys the paperwork back in May of last year when it was initially disclosed charged, but that's all. Thank you.
Thank you. Board members, questions or discussion?
So how many charges she has? Like, she has DUI?
Not,
3 charges she failed to report?
she reported 2 charges on her renewal application, and then there were 3 additional charges that she did not.
3 additional she did not.
I thought it was just the DUI that I didn't disclose. I thought that was the issue. That was the email I received from Jennifer Mitchell. She asked why I didn't disclose that on my renewal application. I sent the court documents for the other charges with my renewal application. I remember like doing that, the disposition report, so. I think I could be wrong.
I have on my notes and I can't quickly find it, maybe somebody from staff, that there was some metabolites present in the laboratory sample that I was going to ask some questions about. I can't find it since the page numbers have recently changed.
Board members, if I may, staff was aware of the results of the testing that was done for Miss Beatty, and the substances that were detected are aligned with the substances that are in her prescription monitoring, her PMP report.
Thank you.
To calculate the fine for non-disclosing. So we have 3 charges, or
There were multiple disclosed initially. I'd have
There's
to
one.
determine how many were missing. To staff, the most important was the DUI. The rest of her charges are failure to comply with court orders.
Okay. So I will go with one. I mean, how I see it as like one violation for renewal. So I will, unless somebody has any other opinion. So I'm ready to make a motion. So I move to approve her renewal application upon paying $250 for failing to disclose charges.
There's just also, just for more discussion, there's a lot going on here outside of the disclosure that is indicating that there could be additional concerns.
You're talking about the short time period with multiple charges? Like
Correct.
within 18 months? Like,
Right.
I mean, yeah.
Something where we have an opportunity for an intervention. Should we take this opportunity for an intervention to?
I mean, if you like to talk to her, like, I don't know if there's any HIPAA information we can discuss privately.
Are you thinking an evaluation?
Correct.
I mean, if I could say something, possibly.
Go ahead.
Yes, but please don't discuss any medical information in open session.
Can I say like one diagnosis I have, or would that be?
No.
I would say no.
I really, I mean,
Okay, can I just?
Hang on one second.
You could offer her the opportunity to go into executive session.
yeah, that's what I would say.
So she can disclose it and we can have a complete discussion.
So should I withdraw my first motion first and then we make a motion to private session?
Yeah, there was no second.
Okay, so it failed. Okay. Yeah.
I'll make a motion for executive session to speak with this licensee regarding public health or private health information, and also seek legal advice if needed.
Second.
A motion and a second. All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Ms. Beatty, you'll get an invitation to join a breakout room. The board members will be present in a private room where the public cannot hear us, and we'll talk to you there.
Okay, thank you.
All right, everybody's back. Discussion after getting additional information from Miss Beatty regarding her medical conditions.
It was very helpful to hear more information from her. And I like to maintain my first motion to approve her application with $250 non-disciplinary fee.
I would like to second.
I have a motion and a second. Any further discussion?
I'd just like to offer a different perspective. I think there's an opportunity for an assessment and an evaluation to be done here. There's so much that happened in this short period of time. It's admirable that it appears that she's on an appropriate track forward, but it would be, I'd have more confidence in her ability to practice as a pharmacy technician safely if we had an approved evaluation. And, just looking again at our mission of serving the public and patient safety, that she is fit to be handling medications and working as a technician in a capacity where she's handling medication. So I won't be supporting that motion. I would support a motion for an order for a psychological assessment and fitness for duty component. Since we do have this opportunity and there's so much that happened in such a short period of time. And I think that's our duty as a board.
I have a motion on the floor. Any last discussion? No, we don't need to do a roll call, I don't think. There can be disagreement. All those in favor?
Aye.
Aye.
Any opposed?
Nay.
Motion carries. Thank you, Ms. Beatty, for being present. We will go to item 18D, Brett Charles Riggle, and I'm recused.
We had a request to postpone for tomorrow.
Okay. All right, then I'll stay. 18E, signature formulations doing business as SIG Form. Is anyone present for SIG Form? Mr. Kalapuri is present. Do we have anybody online that we know of, Steph? Mr. Kalapuri, if you want to go ahead and give us a summary.
Good morning, board members. This is Ram Kalapuri, Compliance Officer with the Arizona State Board of Pharmacy. Signature Formulations doing business as SIGFORM applied for a resident manufacturer permit renewal on 10/2/2025. On the renewal application, SIGFORM indicated that it received the FDA Form 483 observations on 7/29/2025 as a result of FDA inspection conducted from 7/21/2025 to 7/29/2025. 5 of the 8 483 observations were repeat observations from the inspection conducted from 11/14/2023 to 11/22/2023. The Arizona State Board of Pharmacy inspection on 7/1/2025 was unsatisfactory. The following are some of the repeat observations and some crucial observations from the July 2025 inspection. Lack of cleaning validation is one of those, and the HVAC system has not been qualified or evaluated to ensure prevention of cross-contamination of powder-based ingredients, and does not test hormone products for the presence of, does not test non-hormone products for the presence of hormones. During the FDA inspection on 11/22/23, the FDA noted that the purified water system used in product production remains unqualified. During the July 2025 inspection, numerous findings were identified regarding the purified water system under observation 6. Lack of good documentation control is another problem. Some highlights from the July 25 inspection. Pre-filled pH test results as pass in the batch record. The bubblegum, kids mouthwash, and toothpaste batches have inaccurate documentation. It did not confirm the absence of ethylene glycol or diethylene glycol contaminants in any glycerin lots used in hormone drug production. The use of laboratory grade copper sulfate in bubblegum kids mouthwash and bubblegum kids toothpaste. Cleaning personal used industrial grade 70% IPA to sanitize product contact equipment. SIGFARM response to many of the FDA Form 483 observations was that they did not have claims promoting any of their products as drugs, nor did they produce any products that are drugs. For dietary supplements manufacturing, the firm needs to follow DSCGMP 21 CFR Part 111. For cosmetics, there is a law, it's a MOCRA, they call MOCRA, the Modernization of Cosmetics Regulation Act of 2022, which also has a GMP component, which is expected to be released by FDA late December 2025. SIGFARM has no separate quality head. The current production supervisor also serves as a quality assurance lead with no experience in dietary supplements CGMP. As per DSCGMP, the quality control personnel must have education, training, or experience. You may refer to his resume in the packet. The Pharmacy Board inspection suggested that the SIGFARM may benefit from hiring a consultant experienced in dietary supplements CGMP. According to the interim quality head, there has been no communication from the FDA regarding SIGFARM's response to the July 2025 Form 483 observations. I'm ready for your questions if you have any.
Thank you, Ram. Board members, questions or discussion? It looks like they're not present here to discuss.
So, Ram, do we know definitively what regulations that SIGFARM needs to follow? And in your opinion, are they following them?
They have to follow dietary supplements CGMP because they make dietary supplements and they claim they make some cosmetic products. So cosmetics fall under MOCRA. That has a GMP component, and ISO is another standard. But basic CGMP problems are there. When you look at the water quality or batch records maintenance or adding different kind of amounts and recording different amounts and pre-filling the batch record, these kind of issues are there. So they need to, Pharmacy Board inspection was not satisfactory, and the inspector, compliance officer suggested them to hire a CGMP experienced consultant, but they haven't done that. And they have been saying that they are looking for a qualified person to lead the quality assurance department. That has been for months. They haven't found one. So in my opinion, they should immediately hire a consultant to begin with to address all the issues. And in the past FDA inspection, they have official action indicated. It's in the packet, everything is red. But they haven't responded to the current inspection 483 responses, from the firm. So I was looking at FDA dashboard as well. And the recent communication, they said they haven't received any response from FDA. Typically, they take 3 months or so before they respond. So that's the time frame. Yeah, no problem.
Mr. Carlaputi, is there a requirement for them to have since they're not manufacturing drugs or over-the-counter products, is there a requirement for them to have a pharmacy manufacturer permit by this board?
We typically don't regulate the dietary supplement manufacturers, but they wanted a certificate of resale to export out. So some foreign governments require clearance from Arizona Board of Pharmacy. It's called certificate of resale. That's why they got the permit from us. But FDA inspects the dietary supplement manufacturers as well. But for us, because of the permit, we inspect them.
And Mr. Vice Chair, certificate of free sale ensures that they're compliant with CGMP standards, and that's why we require them to be permitted, even though overall nutraceutical companies are not required to be permitted by us with the exception of.
So for clarity, they only need that certificate of free sale to ship outside of the United States.
Yes. And their website also says that their facility is CGMP, you know, all that FDA inspected.
Few concerns, right? So
what are our
maybe
options?
conference maybe?
You could table this matter and request that they appear at a future meeting to answer questions.
Under license, they're applying for renewal, right? And will expire on.
I
what
think
date?
in December.
It is a renewal, but under the statute, because there is a pending investigation, it does not expire until the investigation is complete.
Okay, that's good.
Is there an option to deny at this point, or what would the process be to deny?
You do have that option to deny. If you believe that there is a sufficient basis to deny, then you would just articulate that basis on the record, and then we would issue a notice of denial, and they would have the right to appeal that decision.
And if we did decide to deny, if the board decided to do that, they can still continue to operate within this country and make nutraceuticals and distribute them. They just can't do it internationally because we would not issue a certificate of free sale.
So their permit expires on 12/12/2025. The temporary permit. Yeah.
So that's under concern.
It sounds like they're not listening to the guidance of our compliance officers, and they're not doing what they needs to be done to shore up their operations. So if we deny, at least we'll force them to do something if they want that international market business. If they don't, they can continue.
I would agree with you.
So my motion would be to deny based on all these violations that Mr. Carlopudi so eloquently stated and are in his summary. And that would be my motion to deny.
Second.
I have a motion and a second. Any further discussion? Dr. Gandhi, roll call.
Mr. Braswell, Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis, Ms. Wamsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Nassif.
Aye.
Mr. Anderson.
Aye.
7 ayes, 2 absent, Madam Chair.
Thank you, Dr. Gundy. Item 18F, Create Pharmacy Group LLC. Is anyone present from Create?
Yes, good morning. This is Ty Doyle, counsel for Create. And Dr. Isan Ford is also present.
Good morning, welcome. Ms. Galvin, is there, do we need to get disclosure?
Are you licensed in Arizona, sir?
Yes, I am.
Okay, thank you.
Thank you. Mr. Kalapur, if you could give us a summary of the application, please.
Good morning, board members. This is Ram Kalapudi, Compliance Officer with the Arizona State Board of Pharmacy. Create Pharmacy Group, LLC, I now refer it as Create, applied for non-resident independent pharmacy permit renewal from the Arizona State Board of Pharmacy on September 9, 2025. On the renewal application, Create disclosed a disciplinary action by the Ohio Board of Pharmacy on May 12, 2025. The discipline included a summary suspension of Create license for shipping 41 compounded prescriptions made with the drugs that don't have a USPNF monograph, are not components of FDA-approved drug products, and do not appear on the 503A bulk list. The suspension was lifted on July 10, 2025, following a cooperative settlement agreement reached between Create and the Ohio Board of Pharmacy. The settlement was limited to a reprimand and a $200,000 monetary fine. As part of the settlement agreement, Create ceased shipping the components in question into Ohio. Create provided the Arizona State Board of Pharmacy with the drugs they shipped during the last 5 years. These include 5 of the 8 drugs Create shipped into Ohio that resulted in discipline. Create also provided the names of other drugs that are in a 503 a category 2 list that raise significant safety risks. The drugs that are not in any 503 category with unknown risks as well. The Virginia Board of Pharmacy imposed an automatic suspension tied to the Ohio action. Create entered into a consent agreement with the State of Louisiana Board of Pharmacy on November 19th, 2025. The facts of the case included that Create dispensed 376 compounded products in Louisiana that failed to conform to the minimal standards of acceptable Louisiana pharmacy practice. These products were compounded with unapproved bulk drug substances that are not eligible for human compounding. Create paid a fine of $5,640 and agreed not to dispense any of the compounded products into the state of Louisiana. While providing the list of compounded drugs shipped into Arizona, Create stated that Arizona Administrative Code R423410BC allows Create to use substances for compounding obtained from a source that in the pharmacist's professional judgment is acceptable and reliable. The Arizona State Board of Pharmacy may clarify whether R423410BC allows compounders to use active ingredients with unknown and known safety risks in the compounds even with patient-specific prescriptions and possibly violate Section 503A of the FDC Act and introduce new drugs into the market. And I'm open for your questions.
Thank you, Mr. Calabrese. Does someone from Create want to address the board, or would you like us to go ahead and proceed with questions?
You may proceed with questions. Thank you.
Okay, thank you. Board members?
Madam Chair, just a point of clarification from Mr. Carlapudi. You indicated those drugs are not meant for human use?
The FDA doesn't classify their drugs of unknown safety, so they are being used for human usage at this point. There are some drugs, you find them on Amazon as well. I was looking around. For example, for hair growth, there is a copper peptide. Most of the drugs that were in this packet, or many of them are peptides, which are not in any category. So 503A is a compounder that compounds patient-specific prescriptions, but they have a approved bulk list by FDA where they can grab those items and make compounds if they want to. If the product is not in a USP monograph, or if they don't have a commercially available product with an active ingredient, then they have to look for a product, whether it is in a 503A bulk list. And there are nominations, 503A category 1, category 2, category 3. These are nominated for FDA to consider them to put it under a 503 bulk list. But category 1, FDA uses their discretionary enforcement action. So they allow category 1 products, but category 2 products have known safety risks. Category 3, unknown efficacy issues, So there are several compounders that are using products that are not on any of these lists. And some compounders are using products which are on category 2 and category 3. So
And specifically, the complaint from Ohio was items that were on the category 2 list, right?
They are not on any list. That is one of those. And
Okay.
so some states, they don't permit it, but in our state, we have that rule that allows them. That's why they are putting some experimental drugs into the market.
So that's where I have this huge concern, because as you have shared, compounding is meant to fill an individual patient need. When no commercial available product is appropriate or available, and it's not intended to create new untested drugs. And when a compounder does that and they're using ingredients that have never been evaluated for quality and safety, there's no assurance that that ingredient is what it claims to be. There's no dosing information. There's no toxicity or interaction data. I mean, patients may experience harm that no clinician could ever anticipate because these aren't tested. So that's my stance on it. I don't think these drugs should be available to Arizonans. I think Arizonans deserve the federal standard.
May I speak?
Yes, please.
Hi, I'm Dr. Ford. I'm the Director of Regulatory Affairs and Compliance Pharmacist. I just wanted to summarize that in all the states in Ohio, as well as Arizona, there's been no reported findings of patient harm or no adverse reactions. And we do have a clear, active, unrestricted license in Ohio. And all prescriptions, as you mentioned, were valid patient-specific prescriptions from licensed prescribers, using their clinical judgment within their scope of practice. And all of our APIs, bulk substances, were sourced from FDA-registered manufacturers and full third-party testing for quality before dispensed to patients.
Create has complied with Rule 423, 410 B1C, to the letter.
Madam Chair, can I add a comment? In Ohio and Louisiana, they stopped sending those products because their board did not allow them to ship those products into their states. We allow it because of that rule.
Exactly that. Create has complied with every directive, was extremely detailed and forthcoming in its reporting, and again, follows the applicable rules as pertain to Arizona.
So, Mr. Colliper, your interpretation of it is they are following 410.
Yes.
And in compliance with Arizona law. They may be violating the FDA, which is not our place to opine.
You are correct. Yes. So the FDA I was talking to FDA station chief at one of the locations from East Coast. She was interested in getting all the lists of compounders who are compounding these peptides. They want to be notified.
Ms. Walmsley, I beg to just get some clarity on what you just stated. You stated that this board does not care about, or it's not in scope for FDA meeting FDA standards and FDA regulations. I mean, I think that's the foundation of what we do and the foundation of drug law in the United States. So if the state law allows this and the federal law doesn't, it's not allowed. I mean, that's basic, government. So I would move that we seek legal advice on this rule. That would be my motion.
Second.
I have a motion and a second. Any discussion? All those in favor? Aye. All right, welcome back, everyone. Thoughts, discussion after our legal advice.
I would literally like, to seek more information regarding this practice. So, like seeking FDA opinion. Is that possible to make this motion?
You do have that.
So table, yeah, that's what I'm thinking.
So you're thinking table it to get additional information,
Information,
potentially an FDA opinion.
FDA opinion on this, yes. This is my motion.
Do I have a second?
Second.
Do I have any discussion?
If I might, honorable board members,
I'm sorry.
if I might interject, honorable board members, the creates license expiration comes up on the
It
12th.
would be extended if this
Okay.
motion passes. It'll be extended until a later date.
Okay, and again, I would assert that the proper scope of the board is to apply Arizona law and regulations to the extent that a federal issue exists, and I don't believe that it does. That would be within the purview of federal regulators.
Appreciate your comments. I have a motion on the floor to table for further information. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. We will recess for break. You want to do 1 o'clock, Dr. Gandhi, or are you going to do 1:15?
I'm comfortable with 1 o'clock.
Okay, we'll come back at 1 o'clock, 40 minutes.
Do you know where she is?
All right. All right. Welcome back, everybody from lunch. Dr. Gandhi, if you want to do roll call to reestablish a quorum.
Where did Mr. Tariq go? Sounds good. Mr. Braswell. Mr. Thorwald.
Here.
Ms. Browning. Ms. Davis. Ms. Wamsley.
Present.
Ms. Park.
Here.
Mr. Hogan.
Here.
Mr. Nassif. And Mr. Anderson.
Here.
7 present, 2 absent, Madam Chair.
Thank you, Dr. Gandhi. We are going to go to item 21A due to some scheduling issues for later this afternoon, which is conference for complaint number 25-0248, respondent Gilead Sciences. Good afternoon. If you could please introduce yourselves for the record. If you can unmute yourself. Push the button right in front of you.
Oh, there we go. Paul Giancola, counsel for Gilead.
I'm Robert Ladd, the Senior Vice President and Chief Ethics and Compliance Officer at Gilead, and we do have an individual on the Zoom as well, I believe.
Terrific. If you could please introduce yourself as well.
Hello, Madam Chair. This is John Partridge of Gibson Dunn, here with Gilead Sciences as well.
Thank you. Mr. Jacobson, if you'd like to go ahead and start with a summary, and then we'll allow them to make some opening remarks.
Yeah, good morning. Thank you, Madam Chair. Max Jacobson, Compliance Officer with the Arizona Board of Pharmacy. This complaint was opened by board staff in response to a Department of Justice announcement. The announcement was in regards to Gilead Science paying kickbacks for prescribers. The total amount of the settlement was $202 million that Gilead agreed to pay. And I'll stop there and let them speak about their issues.
Okay, terrific. Go ahead.
Thank you, Madam Chair, and thank you for moving us up. My 2 Gilead representatives have planes to catch early this afternoon. So I'd like to cover 4 points. First, I want to discuss the Arizona connection between Gilead Sciences, the New York settlement that Mr. Jacobson referred to, the INSYS settlement, which was referenced at the by the board at one of the meetings to review this matter, and then specifically the allegations in the complaint. Robert Ladd is going to make a brief presentation, is also available to answer questions as the compliance officer. And Mr. Partridge is available by Zoom to answer any specific questions about the settlement, since he was involved with the settlement, the investigation with the New York Southern District Attorney's Office. So first of all, talking about, how does Gilead fit into, Arizona? In 2024, Gilead, there were about 22,000 patients in Arizona that received Gilead HIV medicines, which include Biktarvy, which is the most prescribed regime for patients with HIV, both in Arizona and in the United States. Some of these treatments are provided through Gilead's support of public health initiatives. Beginning in 2010, these initiatives are called the Focus Program. They currently involve work with Dignity Health, St. Joseph's Hospital here in Phoenix, as well as with the University of Arizona's Public Health Department. In the past, they've worked with what's now known as Valleywise, formerly known as Maricopa Integrated Health System. Gilead continues to innovate new medicines in the areas of virology, oncology, inflammation, including Yeztugo, a recently approved medication for pre-exposure prophylaxis in HIV, which was considered or named by Science Magazine as the breakthrough medicine of 2024. In regard to the settlement that Mr. Jacobson described, $243,000 of that settlement was paid to Arizona under Arizona Access under that particular settlement agreement. So what did that settlement agreement involve? It involved what's called a speaker program. The investigation covered a time period of 2011 through 2017. And by the end of 2017, Gilead had completely remediated the speaker program. But going back in time as to how this program got started up is that in around 2010, the government shifted to a proactive stance regarding HIV treatment. And so one of the things the government wanted was for pharmaceutical companies to educate healthcare providers. And they knew at that point that the education would cover a number of steps, including the fact that by early treatment and the amount of treatment that was given, you could extend the life expectancy of HIV patients, improve quality of life, prevent transmission of disease, and also, and perhaps most importantly, life expectancy. So as part of the education, the speaker program, which as probably many of you know are common among pharmaceutical companies, it was set up in order to educate healthcare professionals about the information involved in terms of the managing complex medications, long-term effects, tolerability, and disproportionate impact of HIV on certain groups. So the New York investigation focused solely on the execution of the speaker program. And what they focused on was things like what restaurants were used, how much were honorariums paid to speakers, were guests allowed to accompany healthcare providers to the conferences, and perhaps, where the conferences were held. Were they held in downtown Phoenix in the middle of summer? Were they held in, Hawaii? Those types of things. And at that point in time, when you're looking at the early 2010s, there was no real good guidance out there as to what were the appropriate ways to conduct these speaker programs. So that's where the time frame was involved. And if, as noted in the papers that we submitted to the board, in 2020, the OIG actually came out with a very detailed fraud alert describing for pharmaceutical companies the right way to do these speaker programs. And fortunately for Gilead, they'd already implemented all of these changes prior to the guidance even coming out. So the other point of the investigation is that Arizona was never a focus of the investigation. And as a result of the settlement, there was no trial or anything like that. Gilead accepted that its conduct was not in conformance with its own standards, as well as the standards that the government believed were appropriate, and they accepted responsibility and continued with their remediation of the speaker programs. Again, this all occurred well before 2020. So as many of you may know, anytime the Department of Justice gets involved in a civil investigation, before settling it, the OIG, the Department of Health and Human Services Office of Inspector General, gets involved. They're part of the settlement agreement. And one of the things that they always do is they need to determine, does this particular healthcare supplier, provider, pose a risk to government programs, and do they pose a risk to the public? And in this particular case, the OIG reviewed the conduct involved, and in particular, they reviewed what Gilead was doing on a going forward basis. And some of the things they looked at was the fact that the conduct was limited in both time and scope. There was no involvement of Gilead leadership, and the conduct did not reflect any type of pattern of abuse. And so as a result of that, the OIG decided that it was not necessary to take any administrative action against Gilead. And typically in these scenarios, the administrative action would be what's called an OIG integrity agreement, sometimes referred to as corporate integrity agreements. Instead, they felt that everything was working appropriately and that Gilead was compliant and it was not a risk to federal healthcare programs in terms of the money that they provide for the treatment of patients with drugs. Mr. Ladd has additional information about the compliance program, but for a moment, I just want to address the incest situation, which is, as you know, that was an Arizona company, and it was a very, very, very different settlement than what we have here. At its core, incest was a criminal case. The company pled guilty to 5 counts of mail fraud, and 8 of its executives actually went to trial, were convicted, and went to jail, including the CEO. What they were convicted of was illegal marketing of Subsys, S-U-B-S-Y-S, which is a highly addictive opioid painkiller from fentanyl. Here, Gilead Sciences, neither the company nor its executives were involved in any criminal activity, nor were there any agreements. Incest also had a civil case attached to it where the company was found to have promoted non-FDA uses or non-approved off-label uses for non-cancer patients of this highly addictive drug. Whereas in this case, Gilead's HIV medicines were always used medically appropriate, and there was no allegations that they weren't. Incest received a corporate integrity agreement on a going forward basis. So I think there was very significant distinction there, and Gilead, of course, did not receive or require any type of integrity agreement going forward. Lastly, I would just want to address the 3 allegations of statutory violations against Gilead. The first involves distributing or rebates of any kind in connection with the sale or prescription of medication. Although this has been characterized as in the opening as a kickback, it was really, a kickback is where you give someone money to do something, or you give them a rebate for prescribing a drug. And that unfortunately, does happen, but this was not a kickback case. This was a case where physicians were taken to conferences or went to conferences, and the expenses at the conferences were excessive. So it's not really a kickback case. And so the first allegation raised in the complaint that there were premiums or rebates of any kind in connection with the sale of prescription medication is really not applicable here. The third allegation, violating a federal or state law or administrative rule regarding manufacture, sale, distribution of drugs or devices, poisons, hazardous substances, or precursor chemicals, is also not really applicable, was there was no finding or admission of any violations of law. It was a civil settlement based upon the conduct which was deemed to be non-compliant. So that really does that fit into the second allegation, which was committing an act that is substantially related to the qualifications of the permittee, or does it demonstrate that the permittee has an actual or potential unfitness to hold the permit in light of the public safety? As mentioned, Gilead has accepted responsibility for the conduct. The conduct has been completely remediated and is currently being monitored on an ongoing basis. So, in conclusion, what we really respectfully submit is that there should not be any concerns about the fitness of the permittee, nor should there be any concerns about the public safety here based upon conduct that that occurred at its earliest 8 years ago. And as we go into 2026, it'll be 9 years ago. And I think you'll find from questioning Mr. Ladd and what he has to say is that Gilead has taken this matter very, very seriously and has very, very strict, fail-safes in place to prevent this type of conduct in the future. Thank you for your time. I know I was a little bit long, and I appreciate your attention.
Thank you very much. Do you have anything you want to add yet, or would you like us to go ahead and proceed into questions?
If you have questions now, feel free to proceed. Otherwise, I can go. I defer to your judgment if you have questions based on what Paul had to speak.
Board members, do we have questions for him, or do we want to let the other individual speak? Go ahead. Thank you.
Okay, I will try to be efficient. Again, I'm Robert Ladd, Chief Ethics Compliance Officer at Gilead. I joined Gilead in February of 2024, and it now makes me depressed to say it this way, but I now have over 20 years in the industry. I have trouble saying it out loud. Over 20 years in the industry experience. So look, where I want to really begin is talking to you about two things. First and foremost, the actions that Gilead made that predated me, and Paul spoke about them in terms of enhancing its speaker programs. But secondarily, I'll talk to you a little bit and very briefly about the state of our compliance organization today. If you look back, as you mentioned before, we have continued to refine our policies, our procedures, and most importantly, our controls with respect to speaker programs to make sure we have limits in place for food and beverages, to make sure the venue is appropriate. If you imagine a speaker program taking place, it should be in a venue that's conducive to education. So making sure it's in a place that is conducive to such, it's not lavish, making sure those meetings take place in appropriate venues as well, as Paul just mentioned. We also had made steps and continue to refine to make sure there are no guests. One of the issues that many companies 10, 15, 20 years ago is additional people coming to the event. Now we have roles, we have logs, we just make sure it's the appropriate attendees who are supposed to be there, have an educational reason for being there. We also now make sure in terms of who the speakers are, that they're trained on what they can speak on, making sure they stay on label. And we also make sure the decisions on which speakers are chosen, that's run by medical affairs. So it is not a question of who is commercially viable, who is a prescriber, not a prescriber. It's based on who has the educational chops or ability to educate and provide information, ask questions for ACPs. So we've continued to refine and work and improve those areas. And although I'm talking about speaker programs specifically, in order to be holistic, we have to think about that, and we have this rigor in place for all of our interactions with HCPs, patients, patient associations, et cetera. Now, in terms of where we are today, here's what I'll say to you. We try to take a 360 approach to compliance. And what that means is, how do we look at several things? How do we make sure we have policies in place? How do we make sure controls are robust? But also, how do we make sure we have senior level accountability? So in other words, not just being competitive, but making sure we emphasize time and time again, we have to do things the right way, ethical way, because ultimately we're here for the benefit of patients. And that's a valued trust that I think we take personally in terms of our mission. The last thing I'll say to you is this. In addition to the proactive work we do, we also monitor these activities on a regular basis. Now, we do that from monitoring that my team does, looking after events have taken place at the data, at the paperwork, at the documentation. We also do live monitoring where we have individuals in my teams and sometimes use third parties who will go to ad boards, or in specifically as we're talking about today, speaker programs to make sure they're fit for purpose and comply with policy procedures. In addition to my team doing it, we also have our broader internal audit function, which I'm sure you're familiar with for most companies who conduct that same type of work on the benefit of making sure we get things and do them right. So Gilead appreciates the risk posed by speaker programs, and ultimately, the best way I can say it is we refuse to bury our head in the sands with respect to this risk. We've consistently made good faith efforts to proactively identify risk, and we've identified that risk, continually worked to improve the controls and the policies to make sure we continue to do the right thing going forward, in the past and going forward. Thank you very much for your time today, and happy to answer any questions you guys might have.
Thank you very much. Board members, I'll open it up for discussion or questions.
So now, when you select a speaker for any event, that should be a prescriber or a doctor in the field, or your own employee?
Very good question. So it depends on the content. So I'll give you a couple examples, Mr. Massif. So if the content is for, let's stick with HIV. So if we have a new product, in order to make sure we have HCPs comfortable with that product, we'll have a speaker program. But it's not based on do you prescribe or do you not prescribe. It is based on your cumulative knowledge about the product, the disease state. And in order to make sure, and this is not unique to us, this is ultimately a best practice across, I would say, pharma, that ultimately what you should see is, the sales force, marketing force may have some ideas about who those speakers can be, but ultimately what you should look for and what we do is medical affairs, so our HCPs who work internally are able to assess CVs, board certifications, appropriate skill sets to decide who those speakers may be. But to your point also, from time to time, we may also have internal speakers. Just as a quick aside, I think what many HCPs would say to you is that they want to hear from one of their colleagues. But when it's appropriate for us to do it internally, we'll do so. But often it might be an external HCP. You're very welcome, sir.
And I believe this case been addressed by New York, right? Yeah. So, Mr. Jacobson, this is only open due to the New York action, right? Like state of New York, correct?
That's correct. This complaint was opened in response to the Department of Justice announcement and
Okay.
settlement.
Okay. So can we have no action?
We
or
can do
do
whatever we
no
wanted.
action or
Dismiss
or
it.
dismiss it or no action?
Yep, we can do whatever we want.
Okay.
Within
just-
the law, yes.
Yeah. Yeah. I mean, like, I really would say like they address the issue and then really they have like a system to prevent that from happening. New York already addressed that. I mean, I believe we can. I mean, I'm leaning toward just like dismiss this one, and then I'll open it for other board members if you have comments. Otherwise, I can make my motion.
I feel better after hearing from them.
Yeah.
Personally.
Okay. So I move to dismiss this case.
Second.
A motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you very much for being present.
Thank you very much.
Thank you for your time today.
Thank you.
Dr. Gandhi, do we want to go back to finish the 18s? Is that where we need to go, or do we have other requests?
No, that's where we should go, Madam Chair.
Okay. We will go to 18G, Boothwyn Pharmacy. Hello,
Yes.
Mr. Yo. If you could please go ahead and introduce yourself online.
My name is Adonis Ducre, and I'm the compliance officer for Boothwyn Pharmacy.
Welcome.
Thank you.
Hi, Susan Trujillo from Corals and Brady outside counsel for Boothwyn.
Thank you. Mr. Castaneda, if you want to go ahead and give us a summary, please.
Sure. Thank you, board members. Ben Castaneda, Compliance Officer, Arizona State Board of Pharmacy. This is a
permit renewal application for a non-resident pharmacy for Boothwin. On their renewal application, they disclose discipline since its prior renewal. The discipline kind of falls into two different buckets. One is home state inspections and the state of California inspection and FDA inspections. The applicant disclosed discipline from the home state of Pennsylvania, which resulted in $1 million fine and the permanent being placed on indefinite probation with terms as stated by the state of Pennsylvania. In addition, the state of California performed an inspection there, and that resulted in a cease and desist order issued to the permit holder for shipping adulterated drug product into the state. There were 3 FDA inspections from 2022, 2023, and 2024. Each inspection had 483 observations noted, and the inspection in 2024 resulted in a warning letter. After that warning letter was issued in 2025, the Board of Pharmacy received notice of a recall for 2 sterile products produced by the company. Ultimately, it impacted 7 semaglutide products shipped into the state of Arizona, which were deemed out of specification.
Thank you, Mr. Castaneda. Ms. Trujillo, would you like to address the board or your client?
Yeah, I don't have any opening statement for you today. Mr. Duker, do you?
Yes, briefly. Thank you for the opportunity to speak today. Boothwin Pharmacy, acknowledges the seriousness of the matters identified by the FDA, California, and the Pennsylvania Board of Pharmacy. We have proactively disclosed our issues to all states when needed or proactively. We've used that as a basis of strengthening our quality systems, leadership oversight, and operational infrastructure. Since July of this year, we have a new pharmacist in charge, director of pharmacy operations, and that's when I was brought on for compliance, and we overhauled our QA department. Since July, we've modernized our quality systems. We discontinued any at-risk dispensing, and we placed all sterile products under hold for release. The California Board of Pharmacy did an inspection, and they reviewed our processes, and they lifted its cease and desist order. On October 16th, the Pennsylvania Board of Pharmacy conducted a full pharmacy inspection. They noted no deficiencies, and they approved us to proceed with construction of additional facility space. We've also have scheduled NABP compounding accreditation and VPP inspection, which should occur this month, which we welcome as part of our commitment to continuous improvement. Boothwin's Pharmacy has been around since 1933, and I think today our systems and oversight and framework are stronger than any point. So we're definitely here to answer any questions openly and affirm our commitment to patient safety and regulatory excellence. So thank you.
I think the Pennsylvania inspection is new information for us. That's not in our packet, is it?
That is correct. I do not have that information.
Okay. Was the status of your probation or your discipline in Pennsylvania lifted as a result of that inspection, or is it still an indefinite probation unless you make the facility changes?
So it's currently it's contingent upon a successful NABP VPP inspection as well as the NABP compounding accreditation, and then paying the remainder. We paid half of the $1 million fine. Once we pay the second half with those other 2 items I just listed, then the probation will be lifted.
And you said you have your NABP inspections scheduled already?
Yes, we actually had our introductory call yesterday with the 2 inspectors, and it's an unannounced inspection, but they did tell us we're on they're going to be there any day.
So do we have an opportunity to perhaps pause on this until we see that the NABP, the inspection report and the Pennsylvania report, so we have a more clear picture?
I think that's fair. I mean, I'm really pleased to see the progress. Certainly some progress even since the original application was written up, but I agree with where you're going with this.
So if NAPP report satisfies,
I think I would
state,
like
we
to
don't need to
see
come back.
the most recent copy of the Pennsylvania inspection that came back with no violations, and then the two NAVP, the NAVP
BP
inspection and the
report.
accreditation.
And do we need them to come back before us, or we just look at the report?
Yes, please.
Yeah.
Board members, if I could add something, please.
Please.
I did happen to find non-disclosed discipline from 2023 from the Pennsylvania Board of Pharmacy, which resulted in a $2,000 fine. That's on page 4116 of your board packet. 4116.
Just ask, this was a renewal application though. Would this have been previously disclosed or would it need to be disclosed in this round?
I would need to look further into that if it was previously disclosed or not.
And if I may ask, is that an individual didn't disclose their own disciplinary action? Or are you saying the pharmacy itself didn't disclose? Because to my knowledge, yeah.
This was on the NABP clearinghouse website for the pharmacy itself.
Okay, it's related to a technician there. Yeah, so
I still think we're moving along in a good direction. Let's extend the license in the meantime.
Is that your motion, Ms.
is this a
Wong?
motion or is just tabled?
I'm ready for a motion if somebody wants to make it.
I'll make a motion to table the permit renewal application and await the inspection reports from most recently occurred in Pennsylvania and the upcoming reports from NABP. And at such time that those reports are available, they will be rescheduled for
Conference?
this meeting. Yeah, appearance at
Appearance.
this meeting. That's my motion.
A motion and a second. Any discussion? All those in favor? Aye.
Aye.
Any opposed? Hearing none, motion carries. Thank you so much for being present.
Thank you.
Okay, we'll go to 18H and 18I, Exela Pharma Sciences.
Excuse me, in the motion, I don't think you included continuing to extend the permit until.
Yeah, we did.
Did it?
Yeah.
Okay.
It's
All right. Thank you.
I see we have some people online. If you could unmute yourself and please introduce yourself for the record, including your position.
Hello, I'm Jeff Gensler. I am Chief Quality Officer for Excel Pharma Science.
Hi, I'm Mark Hartman. I'm Chief Commercial Officer for Excella Pharma Sciences.
Hi, Scott Nykel, Senior Director, Quality Control at Excella Pharma Sciences.
Welcome. Ms. Cheng, if you could give us a brief review of both applications.
Good afternoon, Nancy Chang, Compliance Officer from the Arizona Board of Pharmacy. Excella Pharmacy Sciences is a non-resident manufacturing facility located in North Carolina. The applicant applied for a permit renewal and disclosed an FDA 483 issued on November 15, 2024, and a warning letter issued on July 2nd, 2025, following an FDA inspection conducted in November of 2024. The FDA inspected both the manufacturing facility and a 503B outsourcing at the facility. The 503B outsourcers ceased activity on December 2024. Excella also has a testing facility with license, with permit M00687 on campus, for which they have decided to do not renew the permit. The FDA 483 was issued with 15 observations with subparts, primarily in the area of quality control procedures for preventing biological contamination of drug products and a lack of investigation into out of specification results. Excella provided a response to the FDA 483 on December 9 of 2024 with 87 remediation commitments. As of October 17 of this year, 85 commitments have been completed. The warning letter contained 2 groups of violation relating to the investigation of batch components failing to meet the specification and failing to ensure that laboratory records included complete data. Excella completed a response to the warning letter on July 24 of this year with an additional 45 remediation commitments. And so as of October 17 of this year, 20 commitments have been completed. Pursuant to the warning letter, third-party consultants were enlisted to perform an independent retrospective review of all deviations and investigation for out of specification results. Excella performed full release testing on all retained samples. And on one lot of the sodium bicol, 4.2% injection was found to be out of specification with an arsenic level of 19 per part per billion, which exceeded the maximum specification of 13 part per billion. Excella engaged a medical expert who conducted a health hazard evaluation and opined that there is negligible health risk to the patient. However, they went ahead and voluntarily issued a recall of the affected lot. So as of now, only one health system in Arizona has returned 19 vials of the recall sodium bicol lot. Between October 7, 2024 to September 4 of this year, Excella shipped about 3,000 line items of product that were cited as out of specification in the FDA warning letter, including a total of 54 shipments into Arizona, or around 1,300 vials of the confirmed out of specification sodium bicol 4.2% product. At this point, Excella has not gotten any FDA closure letter, but that is to be waited until the FDA return for a re-inspection in 2026.
Thank you, Ms. Cheng. Does someone from Excella want to address the board, or do you want us to jump straight into questions for you?
Yeah, I would like to address the board, please. This is Jeff Gensler. I'm the Chief Quality Officer at Excella. Just to provide a little background, Excella is a U.S.-based sterile injectable manufacturer in Lenore, North Carolina. We have about 490 employees and about 500,000 square feet of operations, which is state-of-the-art aseptic filling and packaging equipment. Overall, we've had a long history of compliance and successful compliance with the FDA. We've had 17 FDA inspections, 9 of which have had no observations, and 13 DEA inspections with 0 observations. We've also committed to, or have been committed to, driving and modernization through aseptic manufacturing and isolator filling machines and automated visual inspection equipment. The 503 background, just a little background on 503B. Excella really started working in 503B to supply drug shortages, and was instrumental in 2017 around the Hurricane Maria. Saline bag shortage was instrumental also in the 2020 COVID pandemic, and was one of the only companies outsourced to manufacture the COVID vaccine. And then in 2024, the Hurricane Helene saline bag supply as well. As of the inspection, Excella discontinued and deregistered the 503B outsourcing on December 24. With that, I'd like to turn it over to Scott to talk about first I want to talk about the FDA inspection. So the FDA inspection was performed on November 14th through the 15th, or 4th through the 15th, and it was focused on 503B and FDA products. As stated, there were several 483s. We had 15 483s, which resulted in 87 actions, of which 86 of the 87 now are closed. The warning letter also resulted in 45 actions, of which the majority of those are closed. 67% of those are closed. We've requested a meeting with the FDA, or we are in the process of requesting a meeting with the FDA, and are expecting to meet with them in July or January or February. Based on where we're at with our remediation, we expect to be done with remediation in April and expect a reinspection shortly thereafter. With that, I'd like to turn it over to Scott Nykel to talk about the micro and chemistry lab improvements.
Sure. Thanks, Jeff. Afternoon, everyone. Again, Scott Nykel, Senior Director of Quality Control here at Accela. The labs were inspected specifically during our last FDA audit, and the observations that came out of that for both the 43 and the warning letter were immediately addressed. As Jeff had pointed out, there were several action items that came out that we began to address even as they were on site. Long term, throughout this past year and the remediations that were ongoing for both the microbiology and the chemistry laboratories, we enlisted multiple consulting firms, third-party consulting firms, to come in and not only review the items that were identified by the agency, but just holistic full-scale reviews. There were 2 separate consulting firms that evaluated the micro laboratory, and additionally 2 additional consulting firms that reviewed the chemistry laboratory portions of our quality control unit. The primary focus for those reviews were retrospective and prospective reviews of our investigations. So as part of the observation for investigation concerns from the agency, they did a full review of investigations dating back to 2019, which would encompass any product that was on the market. These were primarily investigations that were out of specification and were overturned through laboratory investigations. The thing that came out from this, from the review, was that although improvements were recommended for how some investigations were taken care of or remediated, the overall there was overall agreement with the outcome of all of our investigations that were performed. So that provided us with a level of confidence in the investigation techniques that we were using. However, we do actively look for improvements in processes, and to further align with FDA expectations, we've pulled several improvement recommendations from these consulting firms into place, as well as the addition to our quality team. So I just wanted to give that background briefly. To speak directly to the sodium bicarbonate investigation that did occur, that was called out during the introduction here, we wanted to highlight the fact that during the investigation process for this, we thoroughly vetted through the investigation system that this has been cited to a single lot of manufacturer's glass that was obtained. We have done an extensive, thorough dive through the investigation process, and we have looked back to 2019, which is basically the beginning of our bicarbonate process, or bicarbonate manufacturing process. And we've totaled hundreds and hundreds of lots over that time frame, in tens of millions of units that have been manufactured. And it has been drilled down to a single lot of glass that existed for a time period. We recognized that during this testing for the FDA. We immediately responded to the FDA and our status updates provided to them that this finding had occurred. And although they did not request directly, we voluntarily recalled that lot from the market. Is there anything specific?
No, that's good, Scott. And
that you'd like me to do? Yes, thanks.
Yeah, with that, I'd like to maybe turn over to Mark Hartman, our Chief Commercial Officer.
Yeah, so I want to correct one thing that was mentioned in the beginning in the introduction. We did send you initially a report that had over 3,000 line items of product that was shipped into Arizona because we were trying to determine if you were looking for everything that was shipped into Arizona. Not all of those products are affected, or lots of products were affected by the FDA warning letter, right? So, in fact, there's only 17,300 vials that are in the lot that had the high arsenic that was recalled. In Arizona, there was 1.1% of that lot, or about 190 vials, that were consumed within Arizona. So a very small percentage of it compared to nationwide. As Scott mentioned, we sell millions. We're the second actually largest provider of sodium bicarb in the U.S. Behind Pfizer. Based on the health hazard assessment, there's no impact to patient safety here, including those in Arizona, and there's been no reports of adverse events nationwide on this product. So we couldn't get down to lot specific because wholesalers don't provide us that data down to lot specific. But during that time period, again, as I said, there were only 23 respondents that had responded to a recall that had been shipped from the wholesalers, and only one of those respondents had any vials left. There were 19 vials left, which are on their way back to Excella as part of the recall. And as you know, in recall process, as soon as that's issued, any distribution ceases of that particular lot. All wholesalers that had been shipped the product reported they had zero on hand at the time of the recall.
Okay.
Thank you very much. Board members, questions, discussion?
Guess this might be for Mr. Michael. You mentioned that the arsenic was identified, that it originated from this lot of glass. Can you educate us on that? I'm unfamiliar with that process.
Sure. So as part of release testing, trace metals, which arsenic is included in, is tested for very low levels, right? So the technique that Excella utilizes is ICP-MS, which is inductively coupled spectroscopy utilizing mass spec. So it's determining heavy metals, trace heavy metals by weight. It's a widely used technique throughout the industry, and it is capable of detecting metals at incredibly low levels, so parts per million, parts per billion. Glassware used in the industry, regardless of how clean the glass is and how detailed glass manufacturers are, inherently contain trace amounts of arsenic. It's part of the glass formulation. Historically, glass formulations were directly inoculated with, or the direct addition of arsenic was placed into the glass as part of a finishing feature. Obviously, with knowledge of arsenic levels, heavy metals poisonings, et cetera, that have advanced through the industry in the years, glass manufacturers are doing everything they can to reduce. But inherently, there is some traceability of these heavy metals. So as we do our testing, we test on released material, which will show you any arsenic or any heavy metals that exist in your finished product. So during the testing process, and we obtained higher than specified arsenic levels, we began our investigation process. And from that, you have to rule out the material itself that's used, so any active ingredients, any excipients. You rule out typically any manufacturing equipment, which the industry has all evolved to where we're not having any equipment that would or should be tainted with any kind of these trace metals. So then the next logical place to step is the primary packaging componentry. So your stoppers, or in this case, glass vials that we utilize for our product. So through the investigation, we were able to rule out the material, so the sodium bicarbonate itself, and obviously any of the manufacturing equipment that we used, which leaves the primary packaging equipment, in this case, the glass.
Yeah, there's no sources of arsenic throughout our process, and it's inherent to the glass manufacturing process, and that's why we test for it as a known impurity and have very, very low levels. You know, it was our specification is 13 parts per billion.
Thank you.
Just as one quick follow-up, I'm assuming that these vials that you identified had this level that were the source of the introduction of the arsenic, that you let that manufacturer of those glass
Yes.
vials know that you identified this.
Yes, absolutely. We opened a supplier corrective action with them, and that's in process today.
And you no longer use them, or do you use them as your vendor?
But we still are using them as our vendor, yes. We have a long history with them that's very positive, and we've notified them of this.
Just for my own knowledge, do they have a duty to report that? Because they're not, how are they regulated?
They're providing a component, so they don't have any direct drug product, but they definitely have a responsibility to communicate to any other customers that are using the product from the same manufacturing process.
Very interesting. Thank you.
Additional questions or discussion?
May I add a observation in my investigation? In the investigation, they say that they engage a health expert to look at the safety of the sodium bicarb that has contaminate, and they the health expert opinion was that it was safe based on the calculation that he used to assess and analyze the safety of this level is based on a 30-pound pediatric, because this product used primarily in pediatric population. And so his analysis was based on a 30-pound pediatric patient at a maximum use level of 8 milliequivalent per kilogram per day. And that's considered to be safe within that level. But the question would be then what would happen if you have pediatric patient that are more than 30 pounds? So that would be my concern is, you know, you're not addressing the safety for all other pediatric patient, primarily pediatric patient go up to 14-year-old, and majority, we tend to have a higher, this is based on just an average weight that they were using, but pediatric patient can be up to 100 pounds. So that would be my concern.
Yeah, I think in that case, going down to that minimum was where they went to. Anything over that would still be considered safe, but I think it's a fair question. We can follow up on that.
Yeah, I mean, we can provide you with the health experts report if required. His conclusion at the end of the day is that there was no greater exposure than a single bottle of water.
What's the status of their North Carolina licenses?
That's a good point, because a North Carolina inspection came in yesterday and left with 0 observations.
Thank you. But both are in good standing?
Yes.
Yes. Yes, we're in good standing in all other states. And with FDA did not restrict any shipments to any regions.
Yeah, again, as I mentioned before, too, we're the second largest supplier of bicarb, and for L-cis, which is L-cysteine, which is amino acid that's used in TPNs, we're the only supplier in the U.S. Used by several children's hospitals, clearly within Arizona, for neonate patients too.
Just like if you can summarize in this 1 or 2 sentences, like what if there is any FDA pending like documentation they're waiting for you or whatever, what is the FDA, what the status with FDA now?
I'm sorry, what was the question?
Or any response from you guys or
Yeah, we've been responding to FDA every month with the actions that we've taken. Like Scott said, we've employed third-party consultants and, are very, very transparent with the FDA. We'll be submitting a meeting request with FDA in January and expect to meet with them shortly thereafter and expect an FDA inspection after that. But at this stage, everything all the communications we've received from FDA have been, nothing more than the warning letter
Okay. With no restriction.
with no restriction.
Yeah, all our responses have been voluntary too. Next required time is in January of 2026.
Yeah, we're responding January 16th of 2026, which will include our request for meeting, which we're going through the GDUFA process with them.
So since the FDA has no restriction on them and they've been in communication with FDA, that make me feel better to approve the application. And I can make it my motion unless someone, okay, so I move to approve the application.
I second.
A motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you for being present.
Thank you very much for your
Thank you
time.
very much. Thank you for your time.
We'll do the last application requiring board review, and then we'll take a quick break. Michael Beheen, item 18J. Is Mr. Beheen present? Is he online?
We received an email from him letting us know that he would not be present.
Okay. I don't know that we need him for this. Go ahead, one of you. I don't know who wants to talk, since you're both
Okay.
there.
Christina Castro, licensing administrator. Michael Beanie holds a pharmacy technician license which expired on October 31st, 2021. Mr. Beanie submitted a pharmacy technician license renewal application on September 29, 2025. He failed to disclose a 2024 arrest for DUI. On February 18, 2024, Mr. Beanie was stopped by police officers for driving the wrong way. A blood test revealed a blood alcohol content of 0.156. Mr. Beanie was cited for DUI to the slightest degree and for driving the wrong way. Subsequently, the DUI charge was dismissed. Mr. Beanie was cited for a turning violation and required to complete a defensive driving course, which he successfully completed on May 31st, 2025.
Thank you, Ms. Castro. Board members, discussion, questions?
Ms. Castro, just based on his license expiring in 21, was there any evidence of what he was doing between 21 and now? Obviously, hopefully he's not functioning as a pharmacy tech. Did he say what he was doing?
No, he did not.
He did indicate that he is employed at Walgreens, but the application doesn't indicate in what capacity.
I will recuse. I didn't know that.
It's possible he could be employed as a clerk. We just don't know.
Any thoughts on this, board members?
Well, obviously, there's a failure to disclose. The question is, should there be some type of evaluation based on his DUI being twice the legal limit?
Does it matter because it was dismissed? Right, so
Yes, I would believe that that would factor into any decision that the board would make. He was not convicted of a DUI. The charge was DUI to the slightest degree. So I don't know if that's would encapsulate A, B, A, C twice the legal limit. But he did not disclose that he was charged, but we don't have a conviction.
If I may, if the board is interested in hearing more about Mr. Benny's employment information, we could send him a written request for further information and he would have 90 days to provide a response.
I don't know. I don't know what he's been doing for the last 3 years. Obviously, he was a pharmacy technician and then his license lapsed and now he's applying again. We have some gaps on, was he practicing? You know, was there an employer that missed his license renewal and I don't know. So I just want to make sure that we potentially address that, particularly if we know that he's working at a pharmacy.
Mr. Castaneda was at that pharmacy that he listed as his employer in May of this year, and he was not listed on the employee list of the licensee list, and he listed that employer as being since what, 2024?
June of 2024.
Oh, that's good. That gives me some confidence that he's not functioning as a pharmacy tech. All right. Any other discussion? Is there a motion? Your microphone?
Yeah, I believe there is a failure to disclose a charge. And this is the only concern I have. So I move for $250 fine for failing to disclose a charge, non-disciplinary.
I second.
And approve the application upon.
And approve the application upon paying
Very good.
the fine.
Any further discussion? All in favor, please say aye.
Aye.
Any opposed? Motion carries.
All right, let's take a roughly 10-minute break, come back at 2:15. Okay. We've got everybody back. We will move to item 19A, which is pharmacy technician applicant Joseph David Cornegay. Is Mr. Cornegay present?
Good afternoon. I'm present.
Welcome. Your audio is a little bit quiet. Are you able to speak a little bit louder?
Yes, sorry.
Thank you. And are you able to turn on your camera?
My camera does not work on this device.
Okay. Thank you. Go ahead, Ms. Brown.
Jenica Brown, Executive Assistant to the Deputy Director. Joseph Cornegay applied for a pharmacy technician license on December 31st, 2024. He previously held an Arizona Pharmacy Technician Trainee license, which expired on December 31st, 2024. On his pharmacy technician application, Mr. Cornegay disclosed 2 extreme DUI arrests, which occurred within 6 months of each other. The board considered his application for a pharmacy technician license during the April 2025 board meeting and voted to table his application and issue an interim order for an evaluation. The interim order was executed on April 28, 2025, and required Mr. Cornegay to undergo an evaluation within 60 days. The matter returned to the board in August 2025 for discussion, consideration, and possible action regarding his application, his noncompliance with the timeframes outlined in the interim order, and his request to schedule the evaluation in October of 2025. The board voted to allow Mr. Cornegay to complete the evaluation on or before October 8, 2025. Mr. Cornegay complied with the board's motion and underwent an evaluation with a board-approved provider on October 8, 2025. The results are contained in the board's files for review and consideration. This matter is before the board for discussion, consideration, and possible action regarding Mr. Cornegay's application for a pharmacy technician license and the results of his board-ordered evaluation.
Thank you, Ms. Brown. Mr. Cornegay, would you like to address the board, or would you like us to jump into questions for you?
Yes, I would just like to ask that the board consider, as it makes its decision, that the evaluation was completed as ordered, and that I've had an opportunity to review the report in its entirety. And I would like to say, just for the record, that I agree to follow all of the recommendations in the report, as well as any additional recommendations, orders, or conditions that may be brought forth today.
Thank you, Mr. Cornegay. Board members, the key findings and recommendations of the evaluator on page 4829 of your book. I'll open it up for discussion.
If there's no discussion, I'm happy to make a motion.
Go ahead.
My motion would be to approve the application upon signing a consent agreement for a 5-year probation that includes all the recommendations of the evaluator, the standard terms of probation. If not signed within 30 days, deny the application.
I second.
I have a motion and a second. Any discussion? Dr. Gandhi, roll call.
Thank you, Madam Chair. Mr. Braswell, Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis, Ms. Walmsley,
Aye.
Ms. Spark,
Aye.
Mr. Hogan,
Aye.
Mr. Nassif,
Aye.
Mr. Anderson.
Aye.
7 ayes, 2 absent, Madam Chair. Ayes have it.
Thank you. Thank you, Mr. Cornegay, for being present.
Thank you.
Next up, 19B, Tori Dawson, pharmacy technician applicant. Is Ms. Dawson present?
Yes, I'm here.
If you could please introduce yourself for the record.
My name is Tori Dawson, and I'm trying to reapply for pharmacy technician license.
Okay, thank you. One of the staff want to go ahead and do a review here.
Good afternoon, board members. This is Bridget Perez for Licensing Administration for Arizona State Board of Pharmacy. Ms. Tori Dawson applied for a pharmacy technician license on July 22nd, 2025. Ms. Dawson disclosed a non-disciplinary civil penalty imposed on her pharmacy technician trainee registration. She was fined due to her failure to report criminal charges within 10 working days after the charge was filed. Ms. Dawson failed to disclose the same criminal charges on her technician application. Her pharmacy technician trainee registration expired on June 30th, 2025. On or about May 24, 2024, Surprise Police Department responded to a mail caller referencing a road rage incident involving a female identified as Tori Dawson, who was driving recklessly, followed him, and pulled over into the parking lot of Sam's Club. After officers collected both drivers' statements, both were charged with disorderly conduct. Additionally, Ms. Dawson was charged with threatening after admitting to screaming and yelling at the male driver and threatening to beat up the minor female passenger in the man's vehicle. Ms. Dawson was issued 2 citations, signed them, and was released from the incident. Ms. Dawson pleaded guilty to a Class 1 misdemeanor, disorderly conduct, and was ordered to serve 15 days of jail time, which was to be suspended upon successful completion of the diversion program in anger management and payment of diversion and restitution fees. The threatening charge was dismissed with prejudice. Ms. Dawson has since completed all terms of her plea agreement, and the case was dismissed on July 3rd, 2025.
So, Ms. Perez, just to be clear, this is the same incident that she did disclose on her trainee license, but she failed to disclose on her pharmacy tech license.
That is mostly correct. She disclosed that there was a non-disciplinary civil order that the board reviewed for her trainee registration. That was not disclosed. The charges themselves were not disclosed on the technician application.
Thank you. Ms. Dawson, would you like to address the board?
Yeah, of course. That was definitely on my fault. It was a miscommunication. When I first initially was giving the charges, I was told after a year, as long as I completed everything and didn't like get in trouble or anything like that, then it would be dropped. So when I did my application, I wasn't aware that I had to disclose it because I was assuming that it was cleared off my record, which I now know that I still have to disclose.
Thank you, Ms. Dawson. Board members, discussion, questions? Is anyone ready to make a motion?
I would like to make a motion for a $250 fine for failure to disclose and then approve the application.
Second.
Is that non-disciplinary?
Non-disciplinary.
A motion and a second. All those in favor?
Aye.
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 Any opposed? Hearing none, motion carries. Thank you, Ms. Dawson.
Thank you.
Item 19C, pharmacy technician applicant John Jeffrey Watson. Is Mr. Watson present? Good afternoon. If you could please unmute the mic and introduce yourself.
My name is John Watson. I'm a pharmacy technician trainee at Fry's.
Thank you. Staff want to go ahead and do a review?
I will recuse.
Okay, thank you.
Afternoon, board members. Erica De Leon, licensing administrator. John Watson submitted a pharmacy technician application on September 27, 2025. He currently holds a pharmacy technician trainee registration, which expires on April 30th, 2027. Mr. Watson disclosed charges on his pharmacy technician application. On February 1st, 2017, Mr. Watson was pulled over while driving his company vehicle for failing to maintain in his lane and traveling 15 miles per hour over the posted speed limit. During the traffic stop, a piece of tinfoil with a burnt track was discovered on the front passenger seat, and a second piece of tinfoil with a white crystal was found in the middle passenger seat next to Mr. Watson. The substances were later tested and found to be positive for heroin and methamphetamines. When asked if he had smoked any of the heroin, Mr. Watson stated he was just about to. Mr. Watson was subsequently charged with possession of drug paraphernalia. Mr. Watson pled guilty to possession of drug paraphernalia, a Class 6 undesignated felony. The court suspended the imposition of sentence and placed Mr. Watson on unsupervised probation for a term of 1 year, ordered him to complete substance abuse treatment, including relapse prevention and aftercare, and imposed fines. Upon discharge of probation, the court ordered the undesignated felony be designated a misdemeanor.
Thank you, Ms. DeLeon. Mr. Watson, would you like to address the board?
Yeah, everything she said was true. I had been prescribed oxycodone by a doctor probably a year prior to this and kind of got out of control with that and ended up getting pulled over that day. Since then, I have completed drug treatment. I also was employed by the company that I did my treatment at for a year and a half. I got my peer support certificate. I helped a lot of other people get clean. I've been clean ever since. Yeah, I'm open for any questions.
Thank you for that. Glad to see that you're doing well.
Thank you.
So here we go again with the pharmacy technician trainee that has a trainee registration that obtained it via the old application process that didn't vet the criminal history. And now we're at the technician applicant process and are now just being made aware of this methamphetamine and heroin found in your vehicle. I'm genuinely glad that you met the requirements of the courts. And at the same time, I think we had a similar case, similarly situated, where we did require that technician applicant to undergo an evaluation. And I think that since these are dangerous drugs, this is not just this. I think we do have a duty to get a professional evaluation done. Those are my thoughts.
I have the certificates from the drug treatment. I did 60 days and then I ended up staying another year and a half working there. I mean, I was not a patient at that time, but I also went to Arizona College. I got my for the technician training program they have there and finished that with the 3.9 grade point average. I've done everything I can. I mean, lots changed in my life since then. I'm a father now. I have a 3-year-old little boy and a 3-month-old little girl who's just born. Yeah, I've changed my life around.
Thank you. Thoughts, board member?
I mean, it was in 2017, so it was quite a while ago. And he does have those certificates, so could
I'm
we
right
have
here
him
with me.
submit those to us? Is that a? Oh, yeah, could we do that?
Absolutely. I got them right here with me.
And is that helpful to you, Anderson, or not?
Just trying to be consistent with what we did with the other case.
So have the board certificate. That's for the.
I mean, this is heroin and methamphetamine.
And yeah, I'm just trying to put all this behind me. I made a mistake. I paid for it, and just trying to, do right by my family. I've been
Are
working,
you currently working as a technician?
yeah, since January. Been there since January, no issues. I've been working for just barely over minimum wage, because they won't give me the raise until I get my license. So I'd really like to get the ball moving. I mean, I need to know one way or the other so I can pivot if this doesn't go through.
Would you oppose going to one of our board approved evaluators just for their evaluation?
What does that consist of exactly?
Can somebody else better explain that?
Yeah, we can have Rain speak.
Hello, everyone. My name is Ryan Grease. I'm the PAPA program director. So my experience with a couple of the board approved evaluators is it is typically a 2+ hour interview, which then they will connect with care providers for mental health and or physical medicine, just background, as well as connect a couple different interviews with additional people that you provide names for. So then they would be able to attest to what you are saying is truthful and accurate as to sobriety and clean time. So it takes a couple weeks for it all to come together, for all the background to get compiled, but the actual time itself is a couple hours.
Yeah, I mean, I'm not, expressly, against that. I mean, like she said, it's been like almost 8 years. I just kind of want to move on. But yeah, if that's what I got to do, I'll do it. I mean, it's been a 1.5 year process, me becoming a pharmacy technician, and I've done everything that I could, I think I've done everything right. I just kind of want to get it done with and over with. And
I have a question for Ryan. What's the cost of the program or to be seen by an evaluator?
For technicians, between the two programs that I'm aware of, it's $750 to $1,000.
Does your employer aware of,
Well, they did a background check,
and they're aware
pretty
of the
much
charge and
charge,
everything?
the charge that I was convicted of,
Yeah.
correct? And I'm sure they'd be willing to vouch for me if that's necessary. I'm a good technician.
We have no doubts that you aren't. It's just it's a gap with our former application process that didn't screen this initially, because I think we would have brought this up before you were even issued a trainee registration. But those trainee registration applications, when you applied, did not require this information to be disclosed, and people have fallen through the cracks. And until you get the full license, these questions aren't posed. And I would feel more comfortable if we had a board approved evaluator saying you are fit to practice, and that you're not a danger to the public, just based on the dangerous drugs described in this narrative.
Does the year that I've worked already as a technician, does that apply? Haven't been any issues. That's a year of evidence of me being good at my job, and not being a problem. Just $750. I mean, I can't afford that. I'm not gonna lie to you. Like I said, I have a 3-month-old little baby.
Who were the people that gave you the certificate?
What do you mean?
In other words,
The treatment?
Who was the?
Who issued it?
Who issued it?
Crossroads Treatment Facility?
It's coming. Thank you.
Do you have any experience with Crossroads, or they seem to be bona fide from your perspective?
I would consider them one of the Metro Phoenix area, like, reputable places. Yes.
So my thoughts are that I understand the need for consistency. I think there's some extenuating circumstances in this case, specifically the Crossroads graduation, if you will. So I'd be more inclined to approve the application. I'd like to make a motion to approve the application.
I would like to second.
A motion and a second. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Hearing none?
Thank you guys so much. I really appreciate it.
All right.
Okay. Thank you, sir.
We will go to item 20A. Action on previous action, board case number 25-0392, Aaron John Frey. Is Mr. Frey present?
Yes, I am present. If you can hear me.
Yes, if you could please introduce yourself for the record.
I'm Aaron Frey.
Are you able to turn on your camera, Mr. Frey?
Trying to. Sorry.
Okay, no problem. We'll go ahead and start with introductions in the room here and case review until we can get to you. Thank you.
Right. Is my camera on?
Yep, there you are. We got you.
All right. Thank you.
Hello, everyone. I'm Ryan Grease, Papa Program Director.
Ms. Brown, if you want to go ahead and introduce yourself and do a summary, please.
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Aaron Frey was issued an Arizona pharmacist license by full exam on December 9th, 2020. His license expires on October 31st, 2026. It is currently suspended. On November 16th, 2023, Aaron Frey entered into a confidential and non-disciplinary consent agreement for granting renewal of license, probation with monitoring, and order lifting suspension. The facts that led to the confidential agreement were, in part, Mr. Frey's disclosure of 2 arrests and charges for DUI on his October 2022 application for renewal. Pursuant to an interim order, Mr. Frey's license was suspended for 6 months, and he was required to undergo a substance use evaluation. Subsequent to the evaluation, Mr. Frey entered into the confidential agreement, pursuant to which his license was placed on probation for a minimum of 4 years and 6 months beginning on November 16, 2023. Under the confidential agreement, Mr. Frey also agreed to enter into a contract with PAPA for the entire length of probation. He was required to complete random urine drug screens, attend weekly meetings, undergo biannual reviews, and maintain total abstinence from alcohol, cannabis, and all drugs of abuse. Additionally, the confidential agreement provided that any violation of the order would be considered unprofessional conduct and would result in the matter no longer remaining confidential. On June 20th, 2025, Mr. Frey emailed board staff and indicated that he was ill on June 17th, 2025, and missed 2 drug screens that week. PAPA was aware of the missed tests and stated that they were unexcused and, pursuant to their contract, escalated the testing. On July 9th, 2025, PAPA contacted board staff and indicated that Mr. Frey's most recent drug screen was positive for a derivative of ethanol that is only found after significant amounts of alcohol is ingested. According to PAPA, Mr. Frey indicated that he was not surprised by the test results. He further stated that he drank once a couple weeks ago. Staff opened a complaint against Mr. Frey's license on July 10th, 2025, and subsequently offered him an interim consent agreement for suspension after receiving further information that raised concerns about his ability to safely practice. Mr. Frey responded to the complaint and sent the signed interim consent agreement to staff on July 17th, 2025. His response is included in the board's files for review and contains an apology to the board and statements indicating that he takes full responsibility for his actions. The board considered and approved the interim consent agreement during the August 2025 board meeting, and it was executed on August 25th, 2025. The interim consent agreement placed his license on a suspended status until further order of the board. Documentation related to the steps that Mr. Frey took during the period of suspension are included in the board's files for review and consideration. Mr. Frey underwent a fitness for duty evaluation with a board-approved provider on September 24th, 2025. The results of the evaluation are also included in the board's files for review and consideration. This matter is before the board for discussion, consideration, and possible action regarding the facts of this complaint, the results of Mr. Frey's evaluation, and the suspended status of his license.
Thank you, Ms. Brown. Mr. Frey, would you like to address the board?
No, I believe that was pretty much everything, so I'm good.
Brian, anything you'd like to say?
Yes. Mr. Frey has been candid and walked through the process once this was identified as being a problem. And I don't exactly know what's in your board notes, but some of the events that led up to this happening, I would like to say that although relapse does not have to be part of recovery, it is not unnormal. And I wanted to highlight that this is actually showing that the program worked. Something happened where he had some concerning results or lack of results. We escalated testing. We were able to identify that there was an actual problem and he was able to seek care afterwards. So it takes a moment for some of those things to happen, but I would say that this is a telltale sign of the PAPA program working really well. And I believe that after the better treatment that he's had, that there's no reason to believe at this point that he can't be successful with walking through the monitoring program.
Thank you, Ryan.
So they ask to lift the suspension and put him back on probation?
No, he's currently suspended.
Yeah,
We have an updated evaluation,
just to reconsider. Okay.
and his agreement was non-disciplinary and confidential before. So I believe we would need to offer a new consent agreement with
Probation,
the
new term.
new terms, which would be disciplinary.
Ms. Walmsley, I'll make that my motion. My motion would be to offer a new consent agreement for probation for a minimum of 5 years following the new recommendations of the evaluator, including revised PAPA contract with standard probationary terms, If not signed, move to hearing.
Second.
And that would include lifting the current suspension upon his agreeing to enter this new consent agreement.
That's correct.
And with my second as well.
Motion and a second. Roll call.
Mr. Braswell, Mr. Thorwald, Ms. Browning,
Aye.
Ms. Davis, Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Nassif,
Aye.
Mr. Anderson.
Aye.
7 ayes, 2 absent, Madam Chair. Ayes have it.
Thank you. 20B, complaint number 25-0010. This is for Jennifer Ann Van Hoff. Good afternoon. If you could both introduce yourself.
My name is Jennifer Van Hoff.
My name is Kelsey Whalen. I'm the attorney for Ms. Van Hoff.
Welcome. Ms. Brown, if you could give us a summary.
Jenica Brown, Executive Assistant to the Deputy Director. Jennifer Van Hoff was issued an Arizona Pharmacy Technician license on July 19th, 2011. The license expired on October 31st, 2014. She reapplied for licensure in August 2024 and was issued a new license on October 9th, 2024. Her license is currently suspended. On or about January 6, 2025, a complaint was filed with the board office alleging that Ms. Van Hoff facilitated a drug dealing operation involving the diversion of prescription medications from a former employer in the state of Oregon. Staff contacted the complainant and requested further information and evidence to substantiate the claims. The complainant subsequently submitted 14 videos and 8 video photos related to the allegations. The videos and photos are contained in the board's files for review and consideration. In her response to the complaint, Ms. Van Hoff indicated that she submitted paperwork for an order of protection against the complainant. She indicated that her former employer called her and told her what the complainant was alleging and that she quit her other jobs and has zero access to narcotics. In a supplemental response, Ms. Van Hoff provided a lengthy narrative explaining her own medical information related to members of her family, and information related to the domestic dispute she's in with the complainant. Of note, she also admitted to giving controlled substances that belonged to a deceased family member to another family member. Staff responded to Ms. Van Hoff and provided her with 5 videos that were received by the complainant. Staff requested responses to additional questions related to the videos and her response to the complaint. On March 10th, 2025, staff received a notice of representation from Amanda Kolkinski, in addition to a request for a 30-day extension to respond, which was granted by staff. On April 10th, 2025, counsel for Ms. Van Hoff submitted a response to the allegations and the questions from staff. The response indicates that Ms. Van Hoff was in an abusive marriage with a complainant and contained additional information related to Ms. Van Hoff's health. In response to staff's questions, Ms. Van Hoff admitted to some, but not all, of the alleged conduct, including taking medication and diverting wound care from the return bin at a facility located in Oregon. Staff further requested a list of any and all medications that were diverted. Ms. Van Hoff's response indicated that she could not recall all of the medications diverted from the bin, but recalled Creon, Eliquis, amoxicillin, and testosterone. Ms. Van Hoff's complete response is included in the board's files for review and consideration. On May 8th, 2025, Ms. Van Hoff entered into an interim consent agreement for interim suspension of license and professional assessment for fitness for duty, which was considered and approved by the board during the June 2025 board meeting. Ms. Van Hoff complied with the order and completed an evaluation, and the results are included in the board's files for review and consideration. As part of the investigation in this matter, staff made contact with the Oregon Board of Pharmacy regarding the alleged conduct that occurred at a facility in Oregon. Staff was notified on October 7th, 2025, that the Oregon Board sent Ms. Van Hoff a notice of proposed disciplinary action in August, in which the Oregon Board proposed revocation of her Oregon Pharmacy Technician license, including a $1,000 civil penalty. The information from the Oregon Board of Pharmacy is included in the board's files for review and consideration. As of today, it appears that Ms. Van Hoff's pharmacy technician license in Oregon is still open. There is also the matter of Ms. Van Hoff's renewal for discussion and consideration. Her license expiration date prior to the suspension was October 31st, 2025. Staff has not received an application for renewal at this time. The board may wish to consider allowing staff to approve an application for renewal contingent upon a complete and accurate renewal application with no additional concerns and her compliance with the board's decision with respect to this complaint, or requiring another appearance to discuss the renewal at a future date once an application is received. This matter is before the board for discussion, consideration, and possible action regarding the facts of this complaint, the underlying conduct, the results of Ms. Van Hoff's evaluation, and the suspended status of her license, as well as next steps with respect to her renewal.
Thank you, Ms. Brown. Ms. Van Hoff, would you or your counsel like to address the board?
Yes, please. Thank you all. And to the extent there is some discussion I wanted to mention regarding the evaluation report, I just wanted to see if it'd be appropriate to go to the executive session or proceed with the statement first.
Yes, if we're going to talk about her medical information, we will need to go to executive session.
Okay. Yes, please.
You want to do that now?
If that would be appropriate, yes, please.
Ms. Galvin?
Is there anything that we could handle out here first that does not involve PHI?
I can omit the information that was in any like diagnoses.
Yeah, if you could do that, let's start with discussion and then we can kind of get a little further down the road and then we can go into the PHI discussion.
Absolutely. Thank you all. At this time, we are requesting either a state suspension to address the pending reinstatement application issues, and then also to address the Oregon board matter. And then from that time period, potentially a probationary period in line with the evaluator's recommendations. Ms. Van Hoff takes this matter extremely seriously. She takes full accountability to the extent of her wrongdoing, which we have detailed in our response to the board. At the time of the allegations, Ms. Van Hoff was suffering years of verbal, physical, and emotional abuse. I really encourage the board to review our response as well as the evaluation. I think it does a good job of detailing some of that abuse. On top of that, she was experiencing symptoms related to some of those diagnoses during this time period after grieving multiple losses of both her father and stepfather, on top of the abuse that she was experiencing from her ex-husband. While she was trying to get herself out of this situation, she was forced to initially seek therapy in secret from her ex-husband because he did not believe in therapy. After she told her ex-husband that she wanted a divorce, it spurred various retaliatory actions, including this complaint. She has suffered great financial hardship throughout this entire situation, the past 5+ years. Thankfully, she's been able to seek therapy because of pro bono support from her therapist, and also ample support from her church that she attends. They've been extremely helpful from both emotional support, but as well as great financial help as well. She's been able to finalize a divorce from her ex-husband, and she is still working to this day, and has not had any other issues in terms of her performance, and she's not working in a pharmacy technician role. I will specify that as well. Despite all of this, she again takes full accountability of her wrongdoing. She's been forthcoming and admitted to the wrongdoing to the board, despite it not putting her in the best light. She's participated in the investigation and has agreed to that temporary suspension of her license and undergone the psychological evaluation. She was extremely remorseful for her actions in the past. She intends to continue her EMDR therapy, and she's also began seeing a psychiatrist per the recommendation of the evaluator as well. And again, she's maintained consistent employment as well with no issues, and there are no ongoing concerns of substance abuse, though she'd be willing to provide another drug test or continued drug testing to the extent that would assist the board in feeling more comfortable and regaining trust. While I don't want to minimize these actions, I do want to emphasize that there was no patient harm, and that she did not divert controlled substances from the workplace. She's worked incredibly hard this past year, and working hard to pull herself out of this situation. And I truly think she can regain the trust of this board if she is given the opportunity. So thank you all for your consideration. And we are both open for questioning.
Thank you. Board members?
So the Oregon matter is still pending then?
Yes.
We are not sure about the status. I'm not representing her in that matter, so that is something if the board would be willing to even do like a state suspension so we can follow up. She can follow up with the Oregon board and figure out the status and address that, as well as, of course, the reinstatement application on this current matter as well.
Ms. Van Hoff, do you want to retain your pharmacy technician license?
I do, yes.
But you're not working as a pharmacy technician.
No. I work where I worked prior as a pharmacy technician, but I work in research now.
Why do you want to keep a license if you're not working as a technician?
Because I love working in pharmacy. I would like to stay in pharmacy, but
She's not working as a pharmacy technician pursuant to the consent agreement.
Were you prior to the
Yes.
suspension?
Yeah.
Okay. And you were working in a pharmacy
yes,
that holds a license
yes.
with this board? Because I thought you were working for a physician's office.
Ironwood Cancer and Research Centers. I don't know if it's
Does a pharmacist supervise your work?
we have pharmacists there.
Do they check the prescriptions that you dispense to patients?
Yes.
So we went through this before, like when employer hire pharmacy technician or pharmacist without a permit. It's a different story now, and I believe the same employer, if I'm not mistaken. But I mean, I'm not under. Yeah, I believe it's the same employer. So we can discuss this later. But I'm not underestimating like the difficulty you went through, and but really looking at the video and the photos, we have taken like severe action for something less than that, to be honest. But I mean, if you like to share any, I don't know if needed to share information with us, but if you like to share some like medical information or HIPAA information, we like to hear in executive session.
Ms. Canavong, you look like you want to make a comment.
I just have a question for Ms. Van Hoff. What do you do exactly at Ironwood Cancer and Research Center?
I'm a research assistant.
What does that involve?
We review protocols and every patient that's on a trial, we just keep all the data, a lot of paperwork, just mostly doing data entry.
That involve any dispensing of medications or preparing medication?
I don't prepare medications, no.
Do you have access to drugs?
There's drugs there, they're locked. I mean, they're in locked cupboards.
Do you have access to those?
Yes.
Ms. Van Hoff, when do you anticipate resolution in Oregon?
I was gonna just let my Oregon license go because we're here now and I can't really afford a lawyer up there. So I didn't really know what my options were. I was just dealing with what's here.
So it sounds like they have an open complaint against your license there and that they're investigating. So they have to, there's going to be some disposition to your license.
Yeah.
But you don't know when that final disposition by that board is going to take that action?
No, I'll have to contact them.
Just so when you applied to your current job, they open position for pharmacy technician, right? And you applied and you got this position. So that's exactly what we had. Similar case, I believe, with the same employer. I don't know if you can follow up on this. I don't know.
May I ask one more question?
Yeah.
You mentioned you don't prepare medication. Do you dispense medication?
Like I have access
transport, if a patient is there, it goes from the pharmacy, well, the research to the nurse. So somebody has to sign for it. So I've transported.
Does your current role at Ironwood require a pharmacy technician license?
No, it doesn't.
Thank you.
Madam Chair, a few questions. I think one of the accusations is that you did distribute drugs. How did you come about those drugs?
Which ones? I mean,
I want to be a little cautious just because I think we described everything in detail in terms of our narrative response. And more specifically about which drugs, which like the content. So
Were there prescription drugs involved? Or was it illicit drugs?
I had like the Eliquis, that stuff was returned. Or people bring all their medications back to be destroyed.
And then who were those drugs distributed to? Friends, family members?
My grandmother, yes.
Grandmother?
The testosterone you didn't give to your grandmother. Who'd you give the testosterone to?
My husband.
And fentanyl patch and morphine and all of this.
What does your husband do?
He didn't work.
Ex-husband.
Is he involved in pharmacy?
No, he was border patrol.
and they no longer, the divorce has since been finalized very recently. That's been a big focus of the last year, is working with her family law attorney and going through that process. So I don't want you all to think that she just hasn't been, there's been just a lot in terms of the ongoing abuse, but then, you know, even trying to separate herself from him so she can get her life turned around, I think is the biggest thing.
So what I saw in those pictures, you have different sources for these medications, not only one pharmacy, right? There's different labels from different pharmacies, correct? Because I see like different pharmacy names in each label.
I don't know where all of his pictures are from. I haven't seen them all. I worked at a hospital, and then so the only medications I had access to were there. And then if people ever gave me meds, like family or friends, to return, to destroy, I have those. And the morphine was my stepfather's, who was hospice.
Oh, okay. Okay. So those medications, not all of them from your previous employer. It is given to you by other people to destroy.
Yes.
And you keep them. Okay.
If I may add some clarity around this, the alleged conduct is involving a medication return bin, that she diverted medication from a medication return bin.
And the return bin was housed at this Willamette Valley Hospital.
Yes.
So you had access to this return bin and then took those drugs from the return bin and instead of destroying them with the reverse distributor or what have you, that was the opportunity you had to distribute and divert from that return bin.
No, I don't have access to the return bin. You have to have a pharmacist, 2 pharmacists, and a technician. But if someone that we knew gave me meds to throw in there, because you put it in and then it's, you know, somebody else comes and picks it up. But if it was something like Eliquis or something that I knew somebody paid a lot of money for, I would get it for, like, my grandmother.
So you weren't taking drugs. I just want to make sure that I understand this
I
correctly.
took wound care from work.
You were not taking drugs out of the drug disposal.
No.
People were giving them to you personally to put in the drug disposal bin, and you were not doing that.
No.
And diverting them for personal use.
No.
For your family members.
Yes.
Did you receive any financial compensation from anyone from
No,
these drugs? Were there any illicit drugs involved?
no, just the morphine. I don't,
There is a fentanyl there. I mean, at least the pictures I have here.
I don't know where he would get that. I don't know. The morphine was my stepfather's.
And there's diazepam.
I think Oregon's doing their investigation. They're the ones that have the ability to investigate that piece, right? So I think
If I may, it appears to me in discussions with the Oregon Board of Pharmacy that they are basing their discipline off of the investigation that occurred in Arizona.
So they're throwing on us.
so. We're doing a better investigation than the home state that this occurred in.
I did ask for any additional information and it was not provided to me.
The challenge is like, it didn't actually involve the pharmacy, so there's really not any records. This is all stuff that she had got access to through individuals. Other than the wound care piece, probably.
So like the Eliquis and the amoxicillin. So were these like patients' own meds or something that were left at the hospital that were destined to this bin, or where did you get these ancillary prescription only products to dispose of or with?
Well, I worked there for like 10 years, so you get to know your patients or just other staff members, nurses, and they would just bring in bags of drugs and ask me to dispose of them into that bin.
Board members, if I may divert your attention to the board book, page 5780. I did specifically ask where the medications were obtained from, and in a response to me, it was indicated on point 4. The referenced medication bottles were taken from the medication return bin from Providence Willamette Fall Medical Center. Five, 780.
Sorry, that looks like a response from the attorney.
And what did you do with those medications? So you, for example, Eliquis, did you give it to anyone?
Yes, to my grandmother.
Okay, you took it from patient to grandmother. So all of this medication went to a family member with no money, training, nothing?
Yeah.
Yeah, you asked her. Okay.
Here you said all pharmacy technicians and pharmacists had access to the return bin. As a pharmacy technician, did you have access to the return bin?
With a pharmacist, you have to have multiple people up there. There's different keys that you can even get into it. So
But-
there's 3 signatures that go.
But you're saying that you never took them from the bin, even though that's what you said in your written testimony that came from your attorney.
Which is, it's supposed to go into the return bin, but if I didn't put it in there, I would take it home.
This was the letter that was written. This was the letter that was written by Miss Whalen on April the 14th. The referenced medication bottles, and I'm reading this verbatim, the referenced medication bottles were taken from the medication return bin from the Providence Willamette Fall Medical Center.
Would you be willing to voluntarily surrender your license?
If that's what I need to do, yes.
Before we get into a motion, because they have asked for us to hear their HIPAA information, I think we should do that unless we have other questions that are unrelated to that. And then we can come back and start to think about where we're at for a motion.
I have one other question.
Please, go ahead, Frank.
Was DHS involved in any way, any
No.
involvement? Okay.
I'll make a motion for executive session for private health information and potentially legal advice if necessary.
Second.
All those in favor? Aye. Any opposed? Okay.
Ms. Walmsley, I have a question, if you don't mind, if I could ask Ms. Van Hoff. Can you explain to me, you stated that you would take medications that individuals, hospital staff would give to you, their own personal medications to put in the destruction bin. Is that right? And then so you take these bags of medication, do you open the bag and go through them and see what you might use for someone else? I mean, how did you do this undetected?
Sometimes I would just take the bag home rather than putting it in so I didn't go through the bag there. I would sometimes, yes, just take the bag home.
So out of, how many times did you do that?
I mean, multiple times.
And out of the multiple times and the various kinds of medications that were returned, you only took the one testosterone, you took testosterone for your husband or ex-husband. How many times?
It was whatever like was in the bag. So it
And
wasn't
then, and for your grandma, how many times?
just so like when I got the bags of it, I would just held on to it. And then I gave her the Eliquis all at once before I came to Arizona.
And what did you do with all the medication that you didn't pass on to some other family member?
My husband took it.
As a Border Patrol agent, he took it, and what did he do with it?
Used it for this. I mean, I don't know.
So you gave other prescription medication that was returned to you to dispose of. You picked out what you needed for your husband and your grandma, and then you gave the rest to your husband who was working as a Border Patrol agent.
He wasn't working then as a Border Patrol agent. That's what he did previously.
And I just want to mention, she's not going to probably bring this up because she wants to take full accountability, but a lot of this was at the direction of her husband as well. And of course, she made the choice to do it, and, you know, despite all of this, but I do just want to mention that it wasn't, I think that played a big part of it as well.
So what did you believe he was doing with it? If he wasn't using it personally?
He was a prepper.
He was a what?
A prepper.
What does that mean?
He was like anti-government. So we had 10,000 pounds of food under our house, and he just wanted to have antibiotics and different things for like when COVID hit.
It's a person who thinks there's going to be a disaster and is prepared for all eventualities when the whole country falls apart and there's war.
Thank you. That's a new term. I'm not. No, thank you.
I'm sorry. I noticed from the picture, there is not only 1 or 2 bottles of Eliquis. There is quite few of them.
Yeah.
I wonder if this is coming from one patient or coming from the pharmacy itself. Like you work in the inpatient pharmacy and there is multiple of them and they all sealed, right?
And inpatient pharmacies are all unit
They-
dose
yeah.
packaging, and having Eliquis bottles doesn't make sense with it coming from inpatient. Was it? I can't remember the photograph.
Yeah, I mean, yeah, I see it here. So some of them,
They look like they're mostly community pharmacy prescriptions that were dispensed.
yeah, but here, if you look at the Eliquis, I'm sorry. If you look at the Eliquis, it's no labels on them.
What's your page number? I'm sorry.
I'm just looking at the photos.
They're not on pages.
Notice. Yeah. And with no labels. It is the photos.
They're not on pages. They're on the link
Yeah.
with all the photos.
It is 20-random, it says, the name of the file.
What is it, Derek?
20 underscore random. And you go to timestamp 40. 40, yeah, 40 seconds.
Timestamp 40 seconds.
Yeah.
Did your husband get any of these, ex-husband get any of these from other sources besides you?
I don't know.
How many bottles, for instance, what we're referring to now, over the period of time that you were there, do you think you removed or took home?
There was a pretty big bag, but I didn't do it the whole time I worked. I mean, I was within the last 4 years. So that bag has probably like 15 bottles. So if people get a 3-month supply and take a little and then want me to toss it, then you have a 3-month supply, and that's where probably the unopened bottles came from.
So Ms. Galvin, legal question. So I know when a license is revoked, they have a 2-year period before they can reapply.
That's correct. Revoked or voluntarily surrendered.
That's what I wanted to know. Thank you.
I'd like to make a comment about this. I used to, when I was at the Justice Department, I used to be on the task force on victims of crime and family violence and abuse and all of those kinds of things and all the different studies. And one of the things that I did learn was that it can have tremendous impact on the other family members, what they do and when they do it. And if you're under that situation, there's almost nothing you won't do for that other party during that period of time. And it takes a long time to recover from that. And there are reports and studies from DOJ, Office of Justice programs that show that. So I think we should take that into consideration.
I certainly, I don't want to overstep because I know we can give a statement. I hope the board review some of the extent of some of the abuse. I mean, she wasn't allowed to sit at the table at times for dinner. She had to sleep on the floor at times. He was distributing explicit photos of her to all of her contacts. There's years and years of ongoing abuse, and it's continued to the point where even this year, after she's been trying to now has finalized this divorce, had to still get an order of protection against him. It's been a lot, and we want to be cautious because we don't want to make excuses for the behavior because, you know, she was complicit in it and she did, you know, engage in wrongdoing. And but I think that had a big impact and contributed to the wrongdoing.
Don't know if you like to hear it.
I, for one, am
There is a video here.
in the opinion we should be lenient in this matter.
May I ask Ms. Brown a question? I'm a little bit confused factually. She acknowledged in your series of questions to her that she removed drugs, prescription medication from the destruction bin. Is that right?
That is correct.
And now, Ms. Van Hoff, you're saying that you did not do that you took medication that was supposed to go in the bin and took it. So why did you answer the question in the affirmative and acknowledged that you removed drugs that were already placed in the destruction bin?
I had a bin by my desk where we put like expired meds and that anybody could put empty bottles in.
And you took,
And then that, yeah. So that there's that bin and then there's an actual return bin that goes to,
so the destruction bin by your desk, you removed expired medications from there.
yes.
That was not made clear.
If I may, she did use both of those explanations in her response. So she very specifically stated in her response that the referenced medication bottles were taken from the medication return bin in one of my questions to her. And in a response to another, she stated that she took crayon from the expired drug bin at work.
Did we attempt to talk to the facility about her prior conduct as an employee? Like, were they aware of any of this happening?
I did not. I did engage with the Oregon Board of Pharmacy very early on in my investigation and did ask for any information that they could provide as they had jurisdiction. I did not contact the facility.
What was the status of your employment at that hospital? Were you terminated? Did you leave voluntarily? What happened with your employment at that hospital?
My husband kidnapped the kids and brought them here to Arizona. So I left in December 2023 and they held my job for 6 months. And then I just didn't go back.
They were also aware to an extent of the situation. Correct me if I'm wrong, but I believe that they assisted her in letting her leave to go to therapy, and that's how she would do it, kind of in secret from her husband, because he didn't believe in therapy at the time. And so the employer, I think, was aware of all of this. So I think they were wanting to help to an extent in terms of, trying to get her away from that situation.
Did the employer know about the drug divert? Yeah.
No.
Okay.
Could you comment on those like video when you talk about medications and any of this? Can you comment on this?
Yes.
I believe all of our responses were in the narrative response. I don't know if that
Okay.
would be helpful,
So,
but
so this is, I believe, again, I'm not going to underestimate the difficulty went through, but this wrongdoing is severe for our board. And me personally, I cannot tolerate that. You know what I mean? Like, so I don't know what options you have here. Like, are you willing to surrender your license? Okay. Otherwise we go through the process. So can we make it, that can be a motion, right?
and to be clear, I discussed surrendering. I think she's willing to in lieu of revocation, of course, but obviously I think the goal is whether it's a suspension, probation. I think she does want to prove to the board that regain the trust of the board, but we understand the gravity and the nature of the allegation. So, in the wrongdoing.
Is your employer aware of this? Okay.
Yes.
Mr. Or Ms. Van Hoff, when you were asked if your employer is aware of this and you said yes, to what extent, what knowledge does your employer have?
Everything. I gave them the letter from the Board of Pharmacy. They're the ones who moved out of pharmacy so that I could still have a job.
But you still have access to drugs when you transfer them to nurses and whatever, and they're okay with that?
Yes, I don't do it very often. It's not a.
All right, guys, what do you think?
Well, I already stated what I think, so.
I tend to agree with Frank, and I think the recommendations are robust in terms of the analysis done by the clinical practitioner.
So what was your thought for a motion?
Mr. Nassif, I'll support your motion.
Somebody make a motion and we'll see where it goes. I think we have two thoughts. I want to summarize where we're at right now. I think there's two camps. Some people think we should offer a consent agreement for some term of probation with monitoring, it sounds like. Or some others perhaps think that we should allow for a voluntary surrender. I don't know that we're going to be unanimous.
Madam Chair, before we go there, I'm relatively new to the board, so I made my statement without fully understanding precedent that, might have taken place previously. So I think all the board members should consider that as well.
Thank you. Again, does somebody want to make a motion?
So I'd offer a consent agreement for voluntary surrender to be signed within 30 days or move to hearing for revocation. That would be my motion.
Is
I
there
would second this, yes.
discussion? So voluntary surrender would prohibit her from re-entering practice for a minimum of 2 years, and she'd have to appear before us to get a license again, correct?
Correct.
Any discussion? Dr. Gandhi, go ahead.
Mr. Braswell. Mr. Thorwald,
Nay.
Ms. Browning. Nay. Ms. Davis, Ms. Walmsley,
Aye.
Ms. Spark,
Aye.
Mr. Hogan,
Aye.
Mr. Nassif,
Aye.
Mr. Anderson.
Aye.
5 ayes, 2 nays, 2 absent, Madam Chair. Ayes have it.
Thank you, Dr. Gandhi.
Thank you all.
Thank you. That'll take us to tab 23, 23A. Ratification of approval of a special request that Dr. Gandhi approved. So this was a request for pharmacist Stephanie Stanley to extend her payment. So I need a motion, please.
I'll make a motion to agree to extend the date of the penalty to the end of this year.
I second.
Motion and a second. All those in favor?
Aye.
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 Any opposed? Hearing none, motion carries. Item 23B, discussion, consideration, and possible action regarding the request made by Thai Pham for early termination of probation. Welcome. If you could please introduce yourselves.
Good afternoon, members of the board. Courtney Sullivan on behalf of Mr. Pham, who is presented to my left.
Hi, my name is Thai Pham with Desert Sky Pharmacy.
Welcome. Ms. Brown, would you give us a summary?
Jenica Brown, Executive Assistant to the Deputy Director. Thai Pham was issued an Arizona pharmacist license by Reciprocity on June 28, 2006. His license expires on October 31st, 2027, and is currently open and on probation. Mr. Pham entered into a consent agreement and order for probation of license with continuing education on March 7th, 2025 to resolve board case number 24-0325, which was opened as a result of an anonymous complaint alleging that Mr. Pham was allowing technicians to verify prescriptions under his and another pharmacist's credentials, and that he would bill for a particular NDC but dispense a different NDC. After review and consideration of the complaint, the board voted to offer Mr. Pham the consent agreement. It was executed on March 10th, 2025, and placed his license on probation for a period of 1 year. The consent agreement contains the following terms. Within 1 calendar year from the effective date of the agreement, Mr. Pham shall take and successfully pass the Arizona MPJE, and within 1 calendar year from the effective date of the agreement, Mr. Pham shall complete 3 hours of continuing education in fraud, waste, and abuse. A provision of the consent agreement allows Mr. Pham to seek early termination of probation if he successfully passes the MPJE and continuing education requirements of the order. On September 23rd, 2025, staff received an email from Mr. Pham's counsel requesting an appearance before the board to consider his request for early termination of probation. Along with the request was documentation supporting Mr. Pham's completion of the required CE, as well as documentation demonstrating that he passed the Arizona MPJE on September 3rd, 2025. This information is included in the board's files for review and consideration. Mr. Pham is in compliance with the consent agreement and staff has no concerns.
Thank you, Ms. Brown. Ms. Sullivan or Mr. Pham, would you like to address the board?
Briefly, yes, thank you. Mr. Pham has come a long ways in the last year. The pharmacy has entered into a monitoring agreement with Gates Healthcare, who you will be speaking with shortly. And his inspections have been excellent with Gates Healthcare. Mr. Pham has completed all of the requirements of his consent agreement, as Ms. Brown has indicated, and we respectfully request that his probation be terminated.
Thank you, Ms. Sullivan. Mr. Pham, anything else you'd like to add?
No.
Okay, thank you. Board members, questions or discussion?
So obviously he completed our probation
And the staff doesn't have any
requirements and
concerns.
staff has no concern, so I'm happy to make motion to accept his request to terminate his probation.
A second.
A motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you.
Thank-
I am recused from the next item, so I'll step aside.
Thank you, Ms. Walmsley. This is special request for termination of probation. This is tab 23C. Ms. Brown is presenting on behalf of the board. The subject is Ms. Jenny Yuan. Is Ms. Yuan present? Yes. And Mr. Grease? Ms. Yuan, could you please activate the mic and introduce yourself for the record, please? You're good. You're green.
I have like notes, so.
No, just state your name for the record.
Hi everyone, my name is Jenny Yuan.
I'm Ms. Yuan. And Mr. Grease?
Good afternoon, board members. My name is Ryan Grease. I'm the PAPA Program Director.
Thank you. Ms. Brown, would you like to provide a brief summary for us?
Certainly, Jenica Brown, Executive Assistant to the Deputy Director. Jenny Yuan was issued an Arizona pharmacist license by full exam on January 14th, 2019. Her license expires on October 31st, 2026. It is currently open and on probation. On August 19th, 2022, the board issued a decision and order in board case number 22-0259 regarding Ms. Yuan. The board found that she had been terminated from her position as a pharmacist with Walgreens on April 18th, 2022, after it was determined that she was in violation of company policy for taking prescription medication on 2 different occasions that she did not pay for. Ms. Yuan admitted to having a staff pharmacist create an emergency supply for 3 pills of extended release venlafaxine. She deleted the prescription and stored it and took the medication without paying for it. On April 27, 2022, she took 2 more tablets of extended release venlafaxine from her place of employment without paying for the medication. During Walgreens' investigation of the matter, she admitted to the conduct as alleged. Ms. Yuan failed to appear at the hearing regarding this complaint, and at the conclusion of the proceedings, the board voted to revoke Ms. Yuan's license to practice pharmacy. On July 10th, 2024, through legal counsel, Ms. Yuan submitted a request seeking reinstatement of her pharmacist license. At its August 2024 board meeting, the board voted to approve Ms. Yuan's application upon entering into a consent agreement for probation and monitoring. The agreement was executed on November 6, 2024, and placed Ms. Yuan's license on probation for a minimum period of 1 year. On October 20th, 2025, Ms. Yuan submitted a request to appear before the board to request termination of her probation. PAPA subsequently submitted a letter endorsing her request. Ms. Yuan is in compliance with the terms of her consent agreement, and there are no concerns from staff.
Thank you, Ms. Brown. Ms. Yuan, would you like to make a brief statement for us?
Okay, thank you for the
Ms. Yuan, your microphone didn't activate.
Why does this always happen to me? Okay. Thank you for the opportunity to appear before the board today. This past year has presented significant challenges, and I have worked hard to navigate them responsibly. I have learned the value of asking for help when needed and using available resources to address both personal and professional difficulties. Over the course of my probation, I have also come to appreciate the importance of timely and consistent communication with the board. And with that, I welcome any questions the board may have for me.
Thank you, Ms. Yuan. Any questions for Ms. Yuan, or would we like to just hear from Mr. Grease? Let's hear from Mr. Grease.
Good afternoon, everyone. PAPA has been monitoring Ms. Yuan for the last 12 plus months, just over 12 months, and we have no concerns. She's been responsive to communication, has completed her monitoring per the requirements, and is up to date on all financial payments. So we have no concerns.
Thank you, Mr. Grease. Board members, I'll open the floor for any discussion or questions.
No real I mean, I don't have any questions. I think all of the requirements have been
Right.
fulfilled, and
Yeah.
so I would make a motion to approve the request to terminate probation.
And I'd second.
All right, we've got a first and a second. All in favor, please say
Aye.
aye. Aye. Any opposed? All right, motion carries. Thank you, Ms. Yuan, for being here.
Okay.
Okay, that takes us to item 23D, discussion, consideration, and possible action regarding the request made by Israel Daniel Coronado to terminate his probation. Mr. Coronado? If you could please introduce yourself for the record.
Hello, my name is Israel Coronado.
Welcome. Go ahead, Ms. Brown.
Jenica Brown, Executive Assistant to the Deputy Director. Israel Coronado was issued an Arizona Pharmacy Technician license on January 23rd, 2015. His license expires on October 31st, 2026. It is currently open and on probation. On or about July 26, 2024, Mr. Coronado notified board staff of an arrest on July 13th, 2024 for aggravated DUI, which was his second DUI charge in 3 years. An interim order for substance use evaluation was subsequently issued, which Mr. Coronado complied with. Mr. Coronado entered into a consent agreement in order for probation of license with monitoring, which aligned with the evaluator's recommendations. The agreement was executed on December 17th, 2024, and placed his license on probation for a minimum period of 1 year and required him to participate in a monitoring program for the entire duration of his probation. On October 30th, 2025, Mr. Coronado contacted staff and requested to appear before the board to request termination of his probation. On November 2nd, 2025, staff received a letter from PAPA endorsing Mr. Coronado's request. Mr. Coronado is in compliance with his consent agreement, and there are no concerns from staff.
Thank you, Ms. Brown. Mr. Coronado, would you like to address the board?
Yeah, I just want to thank you guys for the opportunity to come speak to you guys. The past year I've grew a lot. I have been sober the whole time. I'm pretty sure Mr. Grease can attest to that. And I just want to continue that in the future, and still be a tech license holder.
Thank you for sharing, Mr. Coronado. Glad to hear that you're doing well. Mr. Grease, anything you'd like to add?
Israel has been compliant with all of his requirements for the PAPA monitoring, and we have no concerns.
Any additional questions for anybody or discussion or thoughts on a motion?
So considering the board has no concern, right? And he made the requirements, so I feel okay to accept his request to terminate his probation. And this is my
Second.
motion.
A motion and a second. All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Congratulations.
Thank
Glad
you.
to see you're doing well again.
Thank you.
Item 23E, discussion consideration of possible action regarding the request made by Gates Healthcare Associates, Inc. for pre-qualification as an expert consultant for pharmacy permit holders requiring monitoring or other board-ordered consultation. Hello, Ms. Sullivan.
Good afternoon.
I think we have possibly a 5 to 10 minute presentation.
I believe that's correct.
Okay, thank you.
Members of the board and staff, it's my pleasure to briefly introduce you to Ernie Gates of Gates Healthcare Associates. Many of you are already familiar with Mr. Gates and his firm's national reputation. Gates Healthcare provides pharmacy compliance counseling, inspection, and monitoring services for many state boards, healthcare departments, and licensees under broad orders across several states. Their work is routinely relied upon by regulatory agencies to conduct independent investigations, develop corrective action plans, and monitor licensees to verify their ongoing compliance. Our firm has had the opportunity to work with Mr. Gates and his team on several occasions, and in each instance, we found them to be exceptionally competent, responsive, and thorough. Oftentimes, they're able to mobilize an inspector to a facility within a matter of days. I can tell you that I had a client that unknowingly was unaware of a state's requirement for a higher level of inspection for their sterile facility. And Mr. Gates and his team were able to get there in less than a week to complete a full inspection of the facility and work with that facility to get their renewal timely filed with their licensing agency. They also deliver this level of a service at a remarkably affordable cost to permit holders and to the agencies that utilize them. Mr. Gates is here today remotely to request the board consider approving Gates Healthcare as a qualified resource in Arizona for board-ordered consultant decrees and monitoring agreements, and for overflow inspection or compliance review work that may exceed the current board or staff capacity. Having a vetted and experienced partner like the Gates Healthcare team available would give the board additional flexibility, help ensure timely oversight, and maintain consistency in the quality and objectivity of inspections. And as I mentioned in a previous matter before you all this afternoon, Gates Healthcare is currently working with an Arizona pharmacy on their compliance and probation matters. And what I love to see with my clients and Gates Healthcare when they work together is that Gates really likes to work as a partner to make sure that not just that the pharmacy is operating compliantly, but to help the pharmacy maintain that compliance and teach the staff as they're going through inspecting and maintaining compliance, showing the facility why there might be issues and what deficiencies need to be addressed, but more importantly, how to address them long term. So with that, it's my pleasure to formally introduce Mr. Gates to you all.
Thank you. Welcome, Mr. Gates. If you could please unmute yourself and go ahead and introduce yourself.
Can you hear me all right?
Yes.
Are you able to hear me?
Yes, sure can.
Okay. Executive Director and board members, I appreciate this opportunity to do a presentation to you folks and to try to see if you would be willing to, accept our reports for inspections and monitoring and so forth. But if it's okay with you, I don't know if you have the ability to, if I share my screen, I have a quick, I'm sensitive to time for boards, especially you folks have been so busy all day. But I'd like to use the few slides that I have, and it'll give you better direction and in a quicker way. Is that possible?
I don't know that we have the ability for you to share slides. They would have had to be submitted to us in advance of the meeting.
Okay, if you don't mind, I'll read them for you, and because it's more concise, it gives you a faster understanding of what we do. Gates Healthcare Incorporated is a nationally recognized consulting firm and inspection firm specializing in pharmacy operations and compliance since 1994. Gates Healthcare inspection reports are accepted and trusted by numerous state boards of pharmacy and are guaranteed to thoroughly access a pharmacy or outsourcing facility adherence with regulatory compliance standards. Our client base spans across 48 states and Canada, including 503A and 503B outsourcing facilities, veterinarian pharmacies, home infusion pharmacies, long-term care pharmacies, health system pharmacies, and more. Gates Healthcare is a nationally recognized pharmacy consulting firm, but one of the things that we do is, I'm trying to move these slides. Gates Healthcare has developed priority inspection tools based on USP standards, Chapter 797, 795, 800, 825, FDA guidance, DEA regulations, and CGMP requirements and state-specific regulations. Gates Healthcare inspections, reports, and corrective action planning ensures high level of compliance with applicable standards and are performed in a constructive, collaborative manner with the client. There are, in pharmacies, there are approximately 3,500 compounding pharmacies. That's past data, but it's more now. And 50% of these pharmacies do compounding. Thousands of pharmacies across the country are currently involved in compounding. There is a growing interest in starting new compounding pharmacies. Level of experience and expertise vary widely. Many state boards lack the resources and personnel to properly inspect monitoring compounding pharmacies. In recent years, sterile compounding has expanded far beyond the healthcare system. More pharmacies than ever have entered the sterile compounding space, and the need for license and inspection has grown exponentially. Increased scrutiny by the boards of pharmacy, the FDA, and consumer is leading the industry to drive the insured compounding products are being prepared by pharmacies and outsourcing facilities following the highest quality of standards. Pharmacy and outsourcing facilities deserve to have a choice of which company they want to conduct their inspection. These types of decisions include pricing considerations, scheduling capabilities, subject matter expertise, and overall client expertise. Gates Healthcare and its team has a strong, long-standing reputation as a subject matter expert within the compounding industry. Strive to maintain a client-centric and educational approach. Big pharmacies, small pharmacies, compliant, partially compliant, non-compliant, it doesn't matter. We work with all types of pharmacies to raise the bar and ensure compliant with safe and compounding practices are being followed through the country and across the industry.
Ernie,
Gates
can I-
Healthcare is a team with strong, sorry.
Ernie, can I jump in really quick? I'm sorry, I'm going to interrupt you.
Yes.
With the recent revisions to 797, we have seen in other states, not necessarily Arizona, but in other states, that Gates Healthcare and their team actually know and are able to identify more issues and gaps within pharmacy operations than the board inspectors themselves. because they have such a significant background. In fact, he has one inspector that works for him that works, many of their inspectors have worked for other boards in former careers. And having that institutional knowledge of 797, particularly right now, has proven to have an extraordinary benefit to help the pharmacies make that transition to the 797 operations. How'd I do, Ernie?
You did perfect. That's exactly, you don't need me there. No, so I'll just leave with you folks. I'm very sensitive to time and how hard you folks have worked today. GHA is also approved for numerous boards to provide monitoring services for pharmacies under a consent agreement. Our team conducts initial assessments of the pharmacy based on Board of Pharmacy findings and works with boards of pharmacy and licensees to develop an agreed upon a corrective action plan and a timeline for the compliance. Monitoring services can be conducted monthly, quarterly, as per terms and conditions of the consent agreement. GHA reports are sent directly to the board if required. We are in approximately 14 states so far, and we're climbing. I personally am I don't want a marketing because I want myself to be in front of you folks to know that we are very dedicated to this. And since 1994, we've been in the compliance, and we don't sell product. We only sell services. And that's why I'm here. And I would appreciate if the opportunity that we could possibly continue working with you folks. And I thank you for the opportunity to even be here. If you have any questions, I'm here for you.
Thank you, Mr. Gates. Appreciate that. Dr. Grandi, I don't think this is something we customarily approve. I certainly appreciate the information, and it's been I think it's certainly helpful for us to understand that these services are out there, but I don't know that we endorse these types of providers.
If I may, with our other pharmacy that is currently receiving services from Gates Healthcare for compliance monitoring before this board, it was a request that we submit the qualifications of the evaluators. And so having an entity like Gates Healthcare already pre-approved to do that would be one less step for the pharmacies that are placed on probation with monitoring.
I don't personally think we need to take any action on this today.
No, we've noted the presentation, and we know they're out there. So if we need to leverage them, we can certainly do that. But you're right, this is not a normal process for us. We've had other requests also come before us, and we've not previously entertained them. I think this is one of many that we.
If I may, can I add something? We are not looking for any endorsement or a recommendation for us. We just want to become part of an extension that if you have pharmacies from out of state sending, prescriptions into your state, that we just become an extension of your team. And it doesn't have to be us, but we want you to know we're out there and we've been doing it for thousands of pharmacies across the country.
Noted.
Appreciate that. No, we've got that noted. All right. I think we'll move on to reports, tab 24. Sure. Let's take 10 minutes. Come back at 4:05.
Sure.
They don't need your services?
right, welcome back, everybody. 45 seconds. All right, welcome back, everybody. I think we're going to jump to reports. I know we need to take Doug today, so let's start with item 24E, the CSPMP Director Report. Take it away, Doug.
Good afternoon, members of the board. The first topic I wanted to hit on today was through the last few board meetings, we've been talking about the potential of the PMP collecting a pharmacist identifier so that we can measure compliance around the mandate to use the PMP. During our October meeting, the board suggested maybe we do a stakeholder meeting. And it took me a little while to round up a group that I think is a diverse group, a group that is going to encompass large pharmacies as well as independent pharmacies. And I was even able to get a pharmacy vendor that's going to take part in the stakeholder meeting. So with the holidays, we've made that meeting January 13th. It'll be from 9 to 11. And it's just to gain feedback, to hear what industry has to say, concerns. And I've put together the questions I have. I'm going to share them with you right now. And if you have additional questions, it's going to help you, because I'll be back in front of you in February after the stakeholder meeting, and we'll give you the feedback from the stakeholder meeting. But if there's questions that you have that you need answered, maybe you could share that with me so that I can make that stakeholder meeting as valuable as possible for you. But the questions I have include, does there need to be any development work to the pharmacy software system or to the vendor system in order to capture this pharmacist identifier? And if so, what's the cost? Question number 2 I have is, how do we create clear language for the pharmacy community to ensure the expectations of the board? You've heard me say that we recognize that every pharmacy has a different workflow. That workflow would dictate what pharmacist would be the responsible pharmacist for doing that prescription monitoring program check. So I don't know that I want to get into the game of trying to dictate the workflow of a pharmacy. I think each pharmacy owner knows their business better than I do. But we have to have clear communication of what our expectation is. So I think that's an important question for the stakeholder meeting. And then kind of hand in hand with that, would a company capture that identifier through the pharmacy software system or point of sale? I don't know that if you were capturing it at point of sale, there might be developmental work at your point of sale also. So I just tried my best to think of the impact it would have and what questions need to be talked about. And finally, kind of hand in hand with who should be the pharmacist of record. I think it's just important to hear what pharmacies feel like is the pharmacist of record. And I picture it as the pharmacy knows who the pharmacist of record is, and they submit that identifier. And not get into it needs to be the person that checks the PMP or checks the prescription or the person that counsels the patient, because every pharmacy is going to have a different workflow. So I know that there's got to be more questions than that. And knowing that I'm going to come back in front of you in February, do you have questions that you feel like would be valuable for us to talk about?
I mean, Doug, you're really the expert here, but I think you're on the right track of the questions. I think honestly, the discussion as you get into it will probably bring up a lot of other things too that maybe you didn't think about. I know I'm not able to be on the meeting. Where were we able to? Are we going to bring in Dr. Anderson or another board member?
Derek's
I'm already gonna be there. at
Okay,
this
terrific.
meeting. Yeah.
Wonderful. Look forward to the report.
Sounds good.
Just to add on to that meeting is this is not a open to the public meeting. It is just a stakeholder closed meeting. So it doesn't have to comply with open meeting law or anything of that nature. So just for the record and for the public to know.
It can be recorded, right?
It can be.
Can be recorded. Okay, good.
Yeah. Any other questions on that? The only other thing I have to report on is every year we do our CSPMP report, our survey. You probably all received the invite to do the survey, and I always try to give a recap of what we learned from the survey. ARS 362606 requires us to deliver a report to the governor, the president of the Senate, Speaker of the House, and Secretary of State. We did that. We do that on December 1st every year. This year we had 1,681 participants. Out of that 1,681, 1,356 were prescribers, 211 were pharmacists, 91 were delegates, and 23 came from licensing board investigators who use the PMP for their own investigations. That was an increase of 330 completions of the survey from 2024. The areas that we surveyed included the patient utilization report, which is the basic report that every provider pulls. Our state indicators, those are some like to refer to those as our alerts. The 3 alerts we have is when a patient's over 90 MMEs, when a patient is seeing 5 pharmacies and 5 prescribers in 90 days. And finally, if the patient's on an overlapping benzo and opioid. Those, I always bring up this because we do get concerns from the public or from the prescribing community that there's no law being broken. And so why do you send us this? Why do you put this? And it's because we just want a pharmacist or a prescriber to pause and think about it. If patients over 90 MMEs, is that really what you want? Do you want them on overlapping benzos and opioids when that can increase chance of an overdose? So anyways, that's one of the other areas surveyed. Our prescriber report was surveyed, the MyRx report, the CSPMP data error corrections. And then we also survey delegates, and sometimes we just want to know that they are creating an account for each they create one account, but they ask each provider that they're working for permission to be their delegate. And that becomes valuable because you want credit for the query. And if you have one delegate working for 4 pharmacists, one pharmacist may get all the credit, and 3 of you would be saying, I'm not getting the credit I deserve. And that's because the delegate's not register improperly. And we have a lot of materials out on that on our website, but that's a piece of what we surveyed too. So high level wins from the survey. Our integration, users accessing the PMP through an integrated product. That's increased from 50% in 2024 to 66% in 2025. That's from the survey users. It's actually a little higher than that, but for those that completed the survey, that's what we saw. We know that integrated users are more compliant users. Why? Because it's easy. If you have to log into a portal each and every time, there's reasons to not do it. If you just click a button when you're integrated, you're going to be a more compliant user. Additional wins from a compliance effort, the CSPMP team has streamlined and simplified the collecting and sharing of compliance data with the other licensing boards. And you've heard me talk about that. We have quarterly meetings with the other licensing boards. And over 90% of those licensing board investigators are happy or very happy with the response of the CSPMP team. From an education standpoint, there's been increased use of the MyRx report. And in case you forget what report that is, that's the one that when I came up here with Erin Hager from DEA, she talked about how it is important for prescribers to look at their MyRx report because they can identify if there's fraudulent activity on their DEA number. Opportunity-wise, from an education standpoint, attendance for trainings, it's always a challenge, you know. We've tried to move towards creating content that you could go to the website and read at your pleasure versus trying to have live meetings where attendance can be really challenging. And then another opportunity is the education of delegates to properly choose the provider who is required to review the patient utilization report. 15% of delegates responded that they didn't know to select the patient's provider when pulling the patient's PMP report. So not necessarily making sure that they chose the correct prescriber that they were doing a query for. I think the only other thing I'd probably want to highlight is, you know, from the standpoint of our quarterly compliance meetings with the other licensing boards, attendance, it's challenging for the other boards to always make it. And, you know, the more boards we can have together discussing how to make this meaningful for them and meaningful for us, you know, the more the merrier. It leads to better collaboration, and that's really the magic is when we work together with those other boards. So I'll stop there, and if you have any questions for me, I'll answer.
Thank you, Doug. The report was really good. Did you get any feedback from the governor's office?
No, we build binders, Lynn does, and we march some binders over and deliver them, and then I send these reports electronically too. But Dr. Gandhi and I just spoke with Representative Bliss, and you know, one of the recommendations from the Auditor General was that there become a kind of a work group that would help identify the right thresholds for non-compliance. So up to now, it started with us having CSPMP task force meetings me talking about measuring compliance, that goes back to 2020. And we've been moving the needle a little bit at a time, but the Auditor General's asking that maybe the governor's office and the legislators get involved a little bit to create a work group that would help set those thresholds for noncompliance. Dr. Gandhi, maybe.
Yeah, I think just to add, the initial language for the task force was drafted some time ago, and I think the intent was to build a PMP, right? And so our approach now is to create a work group or stakeholder meeting, whatever you want to call it, at the end of the day, kind of hone in on compliance more so than building the infrastructure of the PMP. So we can focus on this. Right now, I think our attendance is, we have a whole bunch of people interested, and as we get closer to the meeting, they start bailing, and then we worry about quorums and stuff. And there's just not a lot of traction as far as what we need to do with it as a useful tool, and how to move the mark from physicians that are non-compliant, maybe pharmacists that are non-compliant. And hopefully this new group, a smaller group, more focused group, will help us move the needle a little bit better. But we do need the support from the governor's office, the Senate, and the House to potentially appoint somebody to this working group. If not delegate us to do it, at least then we've kind of checkboxed a checklist on the auditor's ask, at least, right? At least we move that needle somewhere.
Yeah, our task force statute is ARS 362603. It's really dated. It like Dr. Gandhi said, it's more about building the PMP and integrating healthcare entities and pharmacies. Well, we've been done with that a long time. So during our task force meeting, it's really become me giving a summary of our work for the year and being open to questions. What we talked about is maybe repurposing that statute to be this compliance-driven work group, and that's what we talked about with Representative Bliss.
Any questions?
No, thank you, Doug. Appreciate it. Dr. Gandhi, what do you want to do? How's everybody feeling?
At your pleasure. I mean, my report won't take very long. I don't think the report shall take very long overall. I think we can hammer through it if you'd like.
Anybody have any concerns? Want to keep going or call it for the day? Yeah. Huh? All right, let's do call to the public then. Seems like everybody's really tired, so let's keep the comments to less than 3 minutes if we can. Mr. Morris.
Couple of quick ones. You had a discussion earlier today about when we have pharmacists from out-of-state pharmacies that have Arizona non-resident permits and how to discipline and deal with it. I think there are a lot of levers that you guys are not touching at the moment. You have huge power over the non-resident pharmacy on the pharmacy permit to be able to do that. I don't think you want to sit here and say, we want to have a license for every pharmacist who touches a prescription or has anything to do with every Arizona patient. You're going to need 50,000 more licenses around it. The staff's going to get huge. It's going to be a lot of other issues, but you have a lot more power over the permit itself and what you can do with it and be able to do it. And I think you should be looking at that as compared to worrying about the individual person. You can deal with that in the permit itself, even to say to the permittee, we're going to put you on probation or do discipline because we're not happy with the employees that you have and the staffing and things like that. So I would look at that. I mean, you should discuss it, but there's a lot of power that you have over the permits themselves. And that's where the information is going to come from. The second one, it came up again today, and it's been, I don't know, the third or fourth time I've heard it over the last 2 years, where pharmacy technicians are working in doctors' offices or having some relationship to it, or someone who has a pharmacy technician education training. They may have a license, maybe a trainee or not. And I can see you guys being uncomfortable with it. And what do we do with it? The states around the country have different ways that they've dealt with it. Some of them have tried to prohibit it. Some of them have taken over jurisdiction over the medical offices and the drug dispensing. Some of them, it's going to require statutory changes or rule changes. My suggestion is you actually put together a subcommittee to come up with a bunch of ideas as to how do we appropriately look out for the protection of the public health and safety with the pharmacy technicians in roles that aren't in the traditional pharmacy. What's the right way to look at it? Because there's a lot of different creative things that you can do with those folks. My biggest fear is you're going to, the gut is, well, we're only going to let pharmacy technicians work in pharmacies. And we had this discussion a while ago. Since you don't have the jurisdiction over the doctor dispensing, that means they're going to hire anyone else other than a pharmacy technician, the janitor, the guy on the street to do it. And that scares me more. So I think there's some opportunities to really look at that. And then the third one, just as a comment, when we were talking at the very end, Doug was talking about a stakeholder meeting coming up in January, and I think I heard that it was not a public meeting. I'm a huge fan of public meetings. I think the more public you can do, the better it is to be able to do it. And you limit the public's involvement to a call, but you get more involvement, and it makes it whatever recommendations come out of it are much easier to adopt. Thanks.
Thank you, Roger. Anything else? Hello, Bearcat.
Hello, Madam President, Vice President, Dr. Gandhi, and your entire team. My name is Barakat Gebre Exapier, pharmacist here for the last 22.5 years. I have a compassionate plea to all of you. I did submit a letter on November 17, hopefully to be on agenda meeting for the next one. And this is about gabapentin. We know it's not a controlled substance. We know it's very similar to Lyrica, same class, which is a controlled substance. So I did write a letter in 2017 regarding controlled substances, and that included the history of tramadol and Soma before they were controlled substances, how we dealt with it, how I, as a pharmacist for Walgreens, dealt with other pharmacists, fellow pharmacists, how we cross-reference, see if the patient had it before, for example, at CVS. PDMP that we mentioned is a great tool. I use it for every controlled substance. So in 2018, there was a patient family, a wife who called at 6:45 a.m. And I think that I included in 2018 letter urging the board to make it a controlled substance, that her husband took 6 tablets of the 600 milligram the night before. He couldn't wake up. And she put the phone, tried to wake him up. I told her, what you need to do is call 911 and someone needs to wake him up. I don't know what happened, but that led me to write to the board to consider gabapentin to be a controlled substance. Recently, in Mesa, I was there. Patient wanted to fill gabapentin 300 milligram, 270 capsules. Originally, it was filled in San Diego, a small urgent care type clinic. It was filled there. Came back, there was supposedly was lost in the process of moving. It was filled, and it came to me for the third time to be filled 270 capsules. And it was alleged that she had an incident at work. So having considered what was done, already 270 capsules were dispensed, and the second one, on the third one, I declined. In this case, it prompted me to write again in 8 years, as you, the board members, through the rules and statute, you challenge us to do what is right, to do and protect the public. Today, I'm here to challenge you to put this on the agenda. And as I speak today, gabapentin is a controlled substance in 9 states and 14 other states, including Washington, D.C., made it to be reported under PMP so we can see it. The rest, not yet. And I challenge you to put gabapentin, a controlled substance, and make Arizona number 10 state to be a controlled substance. We have seen so much of abuse. When I wrote you in 2018, I'm going to leave this with you today. I made enough copies. Gabapentin was number 10 drug prescribed. Today, it's number 5. We do know there's so much abuse. So it is time to move it. And I hope to see this on the agenda on the next meeting. And I'm going to leave you this. If you could take one, I appreciate that. And I thank you.
Thank you, Bearcat. Nice to see you.
Before you go, I have a question.
Sure.
Do you address the
No,
metabolite?
no. We can't. We not doing discussion. Only them.
But I'll leave it there.
Naughty, naughty. Naughty, naughty.
Okay, thank you very much.
Do we have anybody else online? Does my resident want to make a comment? No, just kidding. I'm not going to pick on you, Will. Maybe a little bit, though. All right. We will adjourn for the day.
Madam Chair.
Yes.
If I may, just.
Okay.
I know it's day 1 and I know Truman's report is up tomorrow, but Truman, can you introduce your new individual before we recess for the day?
Hello, members of the board. Thank you so much for your time. My name is Truman Leong, Chief Compliance Officer. I had an agenda item for staffing report for the update to the board. Happy to announce that a fund justification was sent to the state and was approved by state legislature to hire 1 additional full-time employee for the position of compliance officer. And we've hired a well-qualified candidate by the name of Michael Veltri here in front of you to give a brief introduction if the board has a moment of your time. Thank you.
Hi guys, my name is Michael Veltri. I'm the newest compliance officer with the Arizona State Board of Pharmacy. I am honored to be here today and it's my pleasure to meet you guys. I know that I'm standing in front of you guys going home for the day, but I'll try to keep it really brief. Just a little bit about me. I've been a pharmacist licensed in the state of Arizona for a little over 10 years now. I've experience in community retail pharmacy and then the last 8 years long-term care pharmacy. I know I've only been with the board for about 4 weeks now, but I want to just say thank you to all the board staff because I truly feel like a member of the team. Everyone's been so welcoming, kind, and patient with me while I'm training. I've been working with Max Jacobson, a compliance officer, and he's been bringing me around pretty much all over the East Valley now, doing routine compliance inspections and some investigations. And I want to just say thank you to Max for, for showing me the ropes. Over the next few weeks, I'll start my time with some of the other compliance officers, and in due time, I'll be out on my own, and looking forward to serving the citizens of the state of Arizona. Thanks, guys.
Welcome, Michael. We're glad to have you. Nice to meet you.
Thank you.
Madam President, may I ask a question of our new compliance officer?
Of him, yes. This is on the
Getting
agenda,
how the
yes.
process worked here. Where did you graduate from pharmacy school?
Midwestern University. Yeah. Thank you.
Dr. Gandhi, does that take us to recess for the
That
day?
does take us to recess, Madam